Thank you. Good morning, everyone. This hearing is in the matter of case number CFI 008-2023 and is being held by way of video conference before Justice Rene Lemiere. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by BSA Ahmed bin Hazim and Associates LLP. Lead counsel is Mr. Martin Kostel. The defendant is represented by Holman Fenwick Willan Middle East LLP. Lead counsel is Mr. Stephen Doherty. Thank you.
All right, thank you. Before I invite Mr. Kostel to begin, I see from the timetable that the estimates that each opening is to be 30 minutes, and then the claimant's evidence in chief 15 minutes. I propose that we should take a short break of approximately 15 minutes, which might conveniently be after the claimant's evidence in chief and before we start the cross-examination. All right, is there anything else to be said before I invite Mr. Kostel to commence?
Not from my perspective, thank you.
No. All right, well, Mr. Kostel, over to you.
Thank you, my lord. As has already been stated, I represent...
Mr. Kostel, could I just ask you to call me Your Honour, not Your Lord?
I'm sorry, as force of habit, sorry.
I know it's all these different jurisdictions.
Yes, yes. Well, there could have been, there are worse things to call a judge. But Your Honour, I'm grateful, thank you. I represent the claimant. Can I just begin by saying I have had a bit of a troubled week last week by way of illness, so I'm not going to be able to speak too loudly, and if I do cough, then I apologise, but I'm trying my best to try and suppress the urge as much as possible.
If you need a break at any time, Mr. Kostel, let us know.
Thank you, and I am using the assistance of Strepsils, which is a miracle of itself. So if you see me with a sweet in my mouth, then I do apologise. And ordinarily I would never do that, but
Understood.
It assists me. Thank you, Your Honour. There are a number of documents that are being provided to the court. Can I just check whether Your Honour has been able to review not just the skeleton arguments, but any other documents in this case?
I have. I believe I've reviewed most, if not all of them. And can I ask you what I have done with the case bundle? Yes. I've downloaded it to make it quicker to access the pages. One downside for that is that I lose the index. So if you could refer to page numbers, not section numbers or anything of that sort.
Certainly. That's helpful. Thank you very much. Your Honour will be happy to know, I think from both sides, we take the view that this is a simple case, and I think my learned friend will agree with that. In fact, I will also go far as to say that not many facts are actually in dispute. Perhaps more the effect of the facts are in dispute. And my learned friend's made his submissions in writing, and as have I. But I just wanted to give an overall flavour to the case and the evidence that's likely to be expected. You know what the claim, Your Honour will be familiar with the claims. There are two alternative premises. One is without cause and one is with cause. The way the dues are calculated differ depending on whether one is with dismissal is with cause or without cause. Sorry.
I'm not sure if I've missed the point, or if I read it incorrectly.
Yes.
But if I read the particulars of claim correctly,
yes.
Do I understand that if it is found that the termination was justified, so that in effect it was a termination for cause,
yes,
you claim less than if the termination was not justified? Have I misunderstood that? That's the way I read the particulars of claim, which struck me as anomalous.
So, page 14 has the prayer to the particulars, and whilst Your Honour's getting that page up. May I explain?
I have it.
Yeah, I was grateful. If no cause is established, as in the dismissal shouldn't have been with cause, i.e. with notice, etc.
Oh, I
then
see. I
yeah,
have misread it.
yeah. Then
Thank you. I understand
yes.
it now.
Okay, well, I'm grateful. So the claimant was employed by EXPRESSO a number of years back. We don't need to go into the details of that. But when it came to the pertinent years that we're looking at, 2016 and 2017, in 2016, the claimant was a senior corporate accountant by designation. A transaction took place within that year. He says he received an instruction from, I think it was the then CEO, Mr. Ramatala, along with Vice President of Finance, Mr. Sam Youssef, to effect a transaction for $1 million effectively. It's not as specific as $1 million. It's $1 million and, you know, something. But for the purposes of this opening, it's roughly $1 million. And that was to be effected by cash transaction. Same thing pretty much happens in 2017. Evidentially, we don't have the instruction email. And he explained, Mr. Moorkathe explains why, which is that he didn't have access to the to documentation. But he gives the evidence, certainly in his witness statement, that he received an instruction. And so in respect of both transactions, instructions received, transaction is effected one way or the other. And we've got the evidence on how Mr. Moorkathe effected transaction by going to the Wall Street Exchange, and we've got there's an exchange of emails between himself and a Miss Betty. I don't know her surname. I don't think Mr. Moorkathe may know her surname, but that may not matter. Now, the issue in this case surrounding these transactions will be whether Mr. Moorkathe should have effected those transactions following the giving of instructions. That's one pertinent issue in this case. Now, when he effected those transactions in 2016, as I say, he was a senior corporate accountant. In 2017, he was a director of finance. Is there a distinction to be drawn? We'll have to see how that's going to be played out in cross-examination. In my submission, that these are designations of seniority. I don't think there's ever a suggestion that Mr. Moorkathe was an actual director. I'm not sure that's the defendant's case. My understanding is the defendant's case is that he was so senior that there was more expected of him, essentially, and he failed far below those standards. Now, you will need to take a view on the account that Mr. Moorkathe gives, and his credibility is clearly an issue. What Mr. Moorkathe says is there's nothing unusual about a cash transaction. We're dealing with a Sudanese parent company. The instruction is received from effectively Sudan. Mr. Abdul Malik himself doesn't disagree that sometimes EXPRESSO would effect transactions for and on behalf of the parent company, Sudatel, based in Sudan. So there's nothing unusual circumstantially. Where the dispute on the transaction arises is what Mr. Moorkathe should have done. Again, doesn't seem to be a dispute whether or not the cash transaction of itself is a problem. Mr. Moorkathe has given evidence of sanctions imposed by the United States of America against Sudan, and therefore the difficulties that arose that brought up. Mr. Moorkathe has given evidence about how there are other transactions that would take place by cash. He certainly has cited another example, which is in the skeleton and in his witness statement, about another large cash transaction. And so essentially what his evidence comes down to is this. There is nothing unusual about what happened. I was given an instruction. I carried out that instruction to the best of my abilities, and I relied on the instructions that were given to me as accurate. Now the defendant is saying, no, you should have done more. You should have essentially challenged it. You should have taken a bit more care. You should have done X, Y, and Z. We'll see what's put to Mr. Moorkathe as to exactly what more he should have done. But that's a very broad overview of the transactions that we're dealing with. Mr. Moorkathe also, I should say, has provided evidence to the court of demonstrating the approval given by higher authority for the use of these transferred monies. What does this go to? This goes to show the legitimacy of the instructions received initially, and that no loss has been suffered by either Expresso or the parent company. In either case, money was required for use in, I think, Guinea, Conakry, and Mauritania for social assistance. Paragraph 38 of my skeleton, I've made that point.
Yes. Mr. Costello, on your case, whose money was it? What was it? Money of Expresso, or was it money of Sudatel, which Expresso was holding on its behalf?
I think that's a good question, but I don't think there's a simple answer, because I suspect that's something that perhaps needs to be explored with Mr. Moorkathe. But what I would say is this.
Well, the reason I raised that, Mr. Costello, is that somewhere in, I think, one of his witness statements.
This is what I was about to say. Yeah.
Yeah. Well,
no, I was about to say this, which is Mr. Moorkathe at some point suggests, I think Your Honour is referring to the control, perhaps, between.
Well, he actually uses the words, I forget the exact sentence, but he says the fund was Sudatel's.
Yes. I can find the paragraph in due course.
I've read it.
Yes, but that it appears that certainly Mr. Moorkathe's position is that money that was taken from Expresso's account is for use at Sudatel's discretion. So Sudatel says, I need X amount. You give me that my money back. I then use it how I wish. And so there is no loss to Expresso in that regard. There is no loss to Sudatel because it's its money. It decides to do what it wants with it. What I suspect Expresso's argument is that it is Expresso's money. It is, even if it were to be used by Sudatel, it is still Expresso's money that has been mishandled and or handed over without proper authorities, etc., and by failing to follow appropriate policies and procedures. That's what I suspect is the argument coming. Can I just say, just on that point of policies and procedures, one of the issues in this case is whether or not there was such policy or procedure. Now, in my submission, just as a marker, because I appreciate closing submissions are for later, but as a marker, we say that you are not going to be, you're probably not going to be too troubled on this point because no policy as such has been exhibited in this case. We've got the company authorization matrix, but as that is what it is. It's the authorization matrix, and again, Mr. Moorkathe doesn't say he didn't get the appropriate authorization or didn't have the appropriate authorization. He says he did. There isn't a policy to say you do this where you are faced with this sort of request. You're not going to see that. There are payment procedure examples that have been exhibited by both witnesses, but produced, in fairness, by the defendant. What material effect that's going to have on this case, we'll have to wait and see. But so far as the claimant is concerned, he suggests nothing out of the ordinary has taken place. What he was dealing with was a request. He carried it out in the confines of his instructions, and that's that. You're going to hear some evidence on the investigation, and perhaps put it another way, the lack thereof of a proper investigation, we say. Now, there are a number of matters that arise here. Firstly, I don't think there's ever any dispute that Mr. Moorkathe was interviewed about the 2017 transaction. Because he wasn't. His investigation was very much limited to the 2016 transaction. When I say that, I mean his interview, because I understand the defendant is saying we had internal audit reports. We had an external report from Parker Russell. Excuse me, Parker Russell. And they dealt with both transactions. That's why I suspect the defendant's argument is going to be at trial. Now, breaking that down, the internal audits are self-serving, but on the face of it, raise queries as to the legitimacy of the transaction, but of itself doesn't prove the illegitimacy of the transaction. It is an audit report, and it may spark an investigation, but that's as far as we say it goes. The Parker-Russell is, we say, a troubling piece of evidence in this case. You would have read the submissions in the skeleton on this, but can I set it out in more broader terms, because I don't want to repeat what's already in writing. But what we have is an investigation by Parker-Russell. The claimant accepts that. We, on behalf of the claimant, will accept that. That as a fact is out there. It's fine. It is a fact in the case. It was commissioned by the defendant, so it seems. It was supposedly commissioned as an expert report. The word expert appears in that document a number of times. I think it's about 30 odd times. But anyway, it refers to itself as a consultative expert report, those words. It reads like an expert report. What it is missing, having said that, is the declaration of truth. But anyway, the evidential status of this report is very much in question in the context of these proceedings, because as we understand it,
but it might help you, Mr. Costel, to tell you that it may help you for me to tell you my provisional view without having heard from you, either of you. That might assist. Is that the report is evidence that the employer received a report which says those things. It is not evidence of the truth of anything in the report.
Your Honour, that's exactly our position, and that was exactly the position we communicated with the defendant's lawyers. Now, in light of that indication, I won't take this matter further, but of course, if you need to hear further from me, then of course I will assist as much as possible. In which case, you do not have evidence of breach of accountancy policies and procedures. That's what we say is the conclusion following that view. You don't have, sorry, let me rephrase that. You don't have expert evidence of a breach of accountancy policies and procedures. You do not have any expert evidence on loss. You do not have any expert evidence in this case, full stop. What you have is the claimant's account of what did or did not happen. You have Mr. Mustafa Abdul Malik, who investigated the case, I think that's fair to say, on his account, made certain decisions in the context of the investigation, and we may have to clarify to what extent his involvement was in the dismissal, but anyway, that may not matter too much. And you've got Mr. Ala Aloob, who was the then HR director, who had some involvement, but albeit I appreciate it from a more limited perspective. That's the overall position so far as the dismissals was concerned and the events. Now, question which arises here is, does that justify dismissal with cause, or does it not? A linked argument or a linked point to consider is negligence, because that is the counterclaim that I think Mr. Doherty will be submitting, or may agree. I don't know. I haven't canvassed his thoughts on this, but whether there is an interconnection between the claim and the counterclaim on that respect, i.e. dismissal with cause is a finding, will require a finding of negligence. I suspect that might be the answer, but we'll see. Now, we have no issue with the following proposition, that the employee must carry out his duties with reasonable care and skill. That is, in fact, enshrined by the employment law itself. I wrote the reference down, but I can't find it now, but I don't think that's a controversial point. I'm going to see if I can quickly find it, but that of itself doesn't give any rise to any difficulties. It's whether or not there is a general negligence or a general duty of care that can be imposed on an employee employer relationship. Duties of care, a duty of care can be imposed, we say, which is incidental or ancillary to the employment relationship. One example we say, and we say it's an obvious example, is in relation to the visa, where an ex-employee's visa must be cancelled within the appropriate period of time stipulated by statute. In this case, I think it was no more than 30 days. But it may even be read in that it must be at least within a reasonable period of time. But in any event, that is a duty which is assumed by the employer, and for which any breach thereof can give rise to a cause of action, which in this case, so it happens, has been pleaded. What we say isn't appropriate is for there to be a duty of care over and beyond that which is enshrined by the employment law. To say that an accountant who has whose conduct has resulted, let me start again. An accountant who is exercising his employment obligations, as in he's doing his job, putting it colloquially, causes loss to occur, to arise at his employer's expense in carrying out his obligations for his employer, i.e. not in a manner that has caused harm to a third party. I think there's a clear distinction. That is too far. That is not something which can be imported from the law of obligations, which the defendant seeks to do so. As a concept, we say that has its flaws and inherent flaws. What typically happens is we're in the context of dismissal cases where there is, for example, gross negligence. Investigations occur, findings are made, and if an employee has been grossly negligent in carrying out of their duties, they're dismissed. You don't then see a claim arising for losses to be recouped, unless it is situations, for example, where a lorry driver has caused personal injury to a pedestrian, and that's the very typical example.
Lister and Romford Ice. Yes,
exactly. More extreme examples have occurred over the years, when which is unfortunate. But for example, a teacher and a student, those sorts of examples, not ones where Mr. Moorkhath is a senior accountant affecting transactions, and now has said, and I was told you need to now pay us $2 million for those transactions. That's where we say the line must be drawn. May I deal with some more? I'm just looking at the time. I've got a few more minutes left. I'm going to just deal with a few points. I haven't gone into the law on dismissal because I don't think my learned friend and I we don't disagree on this, and I think these principles are pretty clear. So I'm not going to go into it now. I'll deal with that in the closing submissions. Visa cancellation, I submit, is pretty clear. There were 2 requests for visa cancellations by legal notices. They were not effected until later. There's a question between the parties whether Mr. Moorkhath rested on his laurels, sat on it, didn't do anything about it, didn't cancel his family's visa, and whenever it was the request that was made in end of September, October, whenever it was, and then or whether this was the employer's doing. There's a question on that. Obviously, from Mr. Moorkhath's perspective, he made his requests. He was waiting for his dues, the question of his entitlements to be resolved, and they weren't, and then his visa was cancelled in November. Far too long, he says. Holiday pay, again, we're dealing with whether or not that is recoverable, whether or not it can be accrued. There's also a question over whether holiday pay accrued over the suspension period can be recovered. We say when one is suspended, you don't seek holiday from your suspension period. You take vacation leave to take a vacation from work, not from suspension. So in those circumstances, it's only logical and sensible that the entitlement is rewarded to the employee at the when he's dismissed after the suspension period. Childcare and air ticket allowance. I know my learned friend has submitted authorities on these points, but we say, firstly, the contract makes no conditions that a year's worth of service must have been completed because otherwise that would be a ridiculous argument where an employee must work for a year and then is entitled to the following year to recoup what he was entitled to under contract. Putting it another way, an employee may begin work, and if he's entitled, he can take out his allowances in the same year. He doesn't need to work for a year to be entitled to that allowance. I know in one of the authorities, I think it's the Abdul Salam Authority, those claims were rejected. The context of those claims were that the claimant employee in that case had not been dismissed. The period of his contracts had expired, and so there was a question mark over the entitlement. That's not the situation here. Again, these might be things that we come back to later. And the penalties claim, I think, is pretty clear what those claims relate to. But I wanted to get through those points and save a couple of comments now for limitation, because that's been raised for the first time now. When one reads the particulars of claim...
I should have looked, but is it pleaded?
No, it's not. You mean by the defence? No.
Yes.
No, it wasn't pleaded by the defence at all. And it didn't appear in any correspondence or... okay, let me just put it another way. The first time it's been raised is by skeleton argument. When one reads the particulars of claim, this is a claim for payments due, whether it's dismissal for cause or without cause. And there's reference made to Article 19.1 and etc. Now, my learned friend says Article 10 applies. He's right. That is the starting point. But that limitation period is subject to Article 20 sub Article 2 brackets 2. And when one goes to Article 20 sub Article 2, I should say, Your Honour, that law is at page 710 of the bundle. Sorry. Article 10 is at 715. And Article 20 is at 720. So looking at Article, can I deal with it this way? Article 19, that was certainly pleaded in the particulars. That relates to payments following termination. The word remuneration is a defined term. So what we have here is the 14-day time period after the termination date for payments to be made. In Article 22, where there is a claim for non-lawful deduction of remuneration or a failure to pay remuneration, again, it's the same defined term, then the 6-month time period, if we look at Article 22A, Roman numeral 1, the 6-month time period runs from the date in which that remuneration should have been paid. That's what our case is. Now, dismissal was on the 23rd of March 2022. Mr. Moorkathe himself will have to be cross-examined, but the claimant's case is, his primary case is he should not have been dismissed with cause, it should have been without cause. So taking that as a starting point, 3 months notice will take him to the 23rd of June 2022, 14 days payment obligation, 7th of July 2022. 6 months is the 7th of January 2023. This claim was filed on the 30th of December 2022. That's at page 1150. Excuse me, 1150. So those claims are, so we say the claim is within time on that analysis. My other friend is going to say, well, Article 20 wasn't pleaded. but that's very difficult, I suggest, with respect to sustain, given that this argument's now been raised, no opportunity been given for clarification, or in fact a repleading that may have been necessitated. And in either way, we say this claim's in time. The loss of earning potential between the general loss of earning claim is unaffected, because that we submit, that is a claim that arises from the law of damages, which requires a finding of a breach. There needs to be an obligation that's been breached, and that is the visa cancellation, which I've made submissions on in my skeleton. That is a tortious duty. That's unaffected by this point, by this limitation period. So, Your Honour, sorry.
Or if you, in relation to, if he was wrongfully dismissed, the claim for payment for the notice period is a claim which is for breach of contract, or arises under the contract rather than under the employment law, doesn't it?
Yes, that's one analysis as well.
And if that's right, the limitation period wouldn't apply.
No, well, 6 years anyway. So, but yes.
Yes.
Yeah. Yes.
All right.
Sorry. Unless there's anything in particular you require any further assistance on. I'm so sorry.
Thank you very much.
I think I need a break.
Help yourself to a strepsil, and if you need to go off camera at some stage, as long as we know you're there, we'll carry on.
Thank you, Your Honour. Thank you.
All right, Mr. Doherty.
Thank you, Your Honour. Hopefully for Mr. Costello, you're going to be hearing from me for the next stint of time, so he can wolf down as many strepsils as he feels assists. I imagine they're only going to touch the sides. I'm conscious of timekeeping for the trial, and aware of the fact that most of what you're going to hear from me, you're going to hear in closing anyway. And so with that in mind, what I hope to do at this moment, as counsel always say, is be relatively brief. I'm going to reserve most of what I have to say until closing. What little I do have to say is going to set out matters which I hope will assist Your Honour in seeing how the defendant frames this case, and in assisting Your Honour with the relevant provisions of law, which it might be helpful to bring you to now, so that you can have them in mind as you hear the oral evidence and consider its relevance to the law you're going to be asked to apply to in due course. So the way I'll tackle that is to confine my opening remarks to the following points. So first is to take Your Honour to the relevant statutory provision which deal with the time limits points my learned friend has already flagged. Second, I'm going to take Your Honour to the relevant legal framework governing termination for calls, which is probably going to occupy the lion's share of the oral evidence. And the point of doing that is, so Your Honour, in listening to that, have in mind the questions that you're ultimately going to need to answer in resolving this dispute. And third, for a similar reason, I'll take Your Honour to the statements of general principle that are relevant to the counterclaim, because again, that will inform the view you take of the transactions and the claimant's conduct with respect to those transactions, which really are at the heart of this case. I'll do that in 1 minute as a very quick overview. I agree with Mr. Costello, the defendant, certainly in the way it views this case, is that it's very straightforward. Even putting to one side the fact that the claim is out of time for reasons you'll hear from me on, the thrust of the defendant's case is that you can't have your finance director, you can't have the only person employed by the company with responsibility over its accounts, handing over $1 million in cash to an individual they don't know, no questions asked. Really, it's as simple as that. This is, we say, about as obvious.
Is that the facts, Mr. Doherty? Is that the facts here, that it was handed over to a person unknown to the claimant?
Yes, that's what happens, and we'll be making the case that when one looks at the chronology, at the point in time that transaction occurs, at the point in time the money is handed over, the claimant's none the wiser as to why he's doing what he's doing, other than someone else told me to do this. And we say that that's. I'm leaving aside
what, if anything, he thought was going to be done with the money. But as I recall it, the claimant says that he handed over the money to, and I'm afraid I find all the names difficult here, but is it Tariq Zain, who was the chairman of the defendant, and Salim Youssef, who he says was the vice president. So do you say
Yes,
he didn't hand it over to them, or he didn't know who they were, or what do you say?
There are differences in the way the claimant puts this, which we'll see. There are some slight discrepancies between what he says in his witness statement and what he says in his interview back in 2021. But the one consistent thread in both of those is that the person leaving the room holding the bag of cash is a third party who he doesn't know. So that's the consistent.
If he was in company with the other two and appeared to be taking instructions from the other two, does it matter if he was just the bag carrier?
Yes, it does. And it's because of the capacity in which he's employed. And really, that's what we say. For an accounting professional, for someone who is, on his own admission, the only person acting in this capacity for EXPRESSO, we say that what happens in this case is as obvious a dereliction of duty as you can imagine. And we say that it's simply inconceivable that any reasonable or responsible employer or company would continue to employ an individual in any capacity, let alone in charge of its company's finances, in circumstances where they have permitted the release of money in this way. And for those reasons, as we go through the facts, we say it's one of those no-brainer terminations for cause. If you have $1 million out of a company in a way that it can't properly be retraced because your accountant hasn't kept any proper accounting records for those transactions, there can't be any proper trust or confidence in the employment relationship. And as obvious as we say that statement as it is, and as much as one could actually take the view that it might have been perfectly reasonable for the defendant in this case to simply summarily terminate the claimant's contract of employment when it found out about these transactions the very first time, we say the steps thereafter are actually pretty reasonable and pretty prudent, if not excessively prudent. And so it won't have been lost on Your Honour that it was, of course, to the claimant's benefit that he was being granted, in effect, 10 months full pay while suspended, as compared with an option that would have been perfectly open to the defendant of just handing him in his notice and giving him 3 months pay instead of 10. So that puts him in a considerably better financial position, certainly than if he'd been summarily dismissed at the outset without investigation, or even if he'd just been handed his 3 months notice and put on gardening leave. But it's out of a sense of fairness to the claimant that the transactions are subject of lengthy internal investigations, and more than that, they're referred to an external accountant for review. And both processes come to the same, and what we will say are inescapable conclusions about the claimant's culpability when it came to these transactions. And so it's difficult to see from the defendant's perspective what more it could have or should have done in this case. Not only did the defendant act reasonably in terminating the employment for cause, it's difficult to see when presented with the materials that were available at the point in time the decision was taken, how a reasonable company exercising reasonable judgment could have reached any alternative outcome. And once that happens, our position is the claimant's employment benefits are promptly paid. For reasons I'll deal with in closing submissions, we actually say that the defendant has been more generous than perhaps it could have been on some of those entitlements had a strict contractual entitlement been applied. And so that, in short, is why we'll be asking Your Honour to dismiss the claim entirely. I'll come on to address those points of law. I just wanted to pause very briefly to address Your Honour's observation that you raised at the outset, which is that there's the appearance that in this case, the claimant is claiming more if he was properly dismissed for cause. And that does appear to be the... I think that does appear to be the case if one looks at the particulars of claim, because the way it's ordered is at page 14, which I think my own friend took you to. We can see that the first amount, which is the 875,000 dirham, brackets no cause established, that is the claim that includes an entitlement to notice pay and to the gratuity that would have been applicable. And the higher amount is then if cause is established. And the reason for that is effectively down to how Mr. MOORKATH frames what he's referred to as his loss of earnings claims, because in essence what he's saying is that from the very date of his dismissal all the way through to November, he would have been working if it hadn't been for this visa issue. And so he's claiming his salary for that entire window anyway. There are a host of things wrong with that claim, which I'll deal with in closing, but that's probably the explanation of why that claim is higher in value than the other. As I say, our position is that aspect of the claim is misconceived. And so at best, what one will be looking at in this alternative claim of cause is established is that you remove the loss of earnings entirely, and the amount claimed for actual employment benefits would take that away. As I say, Your Honour, I'll address you quickly on the points of legal framework. And as I say, the reason for doing that is because it will probably colour some of what you hear in the evidence. The first is limitation. It's in the claim form. I think it's accepted by my learned friend that this is a claim for unpaid benefits arising on the termination of the claimant's employment. The statutory basis for those pleaded claims is the DIFC employment law. And if Your Honour turns up...
If the claim for 3 months' notice, does that not arise from the contract?
It arises from the contract, but it's a contract of employment, and as such, it's the employment law is a self-contained legal framework. So a claim for employment benefits under the employment law is subject to the limitation periods in the employment law. It's not to be treated as a contract. I understand there's authority on that point. I'll put a note down, Your Honour, so I can take you.
Yes, please.
Do that. Sorry, bear with me for a minute. I'll flag that because I think it's an important point.
Yes.
It's, I believe, in case you want some reading before bed, I'll probably come to it tomorrow, but I believe it's the case, which I'm just getting the page reference for now. I'll not give you the, well, it's J tab 12, but it's page 1024. And I believe it's the Lutfi case that deals with this point.
All right, thank you.
But the point really is that the employment law is self-contained. If you've got a claim under the terms of an employment contract, the limitation period that applies is what's set out in the employment law, not what's set out in the contract law or in the court law.
Yes.
And that position is changed under the 2019 employment law framework. It used to be that the old employment law framework didn't have its own self-contained limitation provision, but that's changed. And the Court of Appeal reviewed the transition in the Abdul Salam Court of Appeal decision, which I'll refer you to in a moment. But if one goes to page 715 of the bundle, you find the limitation period that applies. So subject to Article 22 and Article 61(2), a court shall not consider a claim under this law unless it's presented to the court either during an employee's employment with the employer or not later than 6 months after the relevant termination date.
Now, a relevant fact might be, Mr. Doherty, that if the limitation period in effect works as a defence, then at least with the law I'm familiar with, if you haven't pleaded it, then you can't rely upon it. May be different if it acts not as a defence but as an element of the cause of action. And I don't know what you say about either of those points.
Yes, Your Honour. So we say that this is one of those automatically applicable provisions based on the way it's framed. The important words are that a court shall not consider a claim under this law.
Right.
And for example, if one were to compare it, you can see differences to how the limitation framework works in the UK. The way the UK would deal with the contract is an action founded on contract shall not be brought after the expiration. What the employment law is saying is that the court cannot consider it unless it's presented within that time.
Yes.
And so whether it's pleaded or not, it's not a discretionary provision of law. It says the court can consider it.
Yeah.
And this is a provision that has been looked at already by the Court of Appeal. So this is another one of the EXPRESSO cases. It's the Abdul Salam case. It's at page 920.
Right.
And paragraph 83 of that judgment at page 920. It's approximately halfway through that paragraph. I don't know if Your Honour has the reference.
I do.
It's starting with Article 10 thus. So Article 10 thus imposes a bar against consideration by the court of any claim commenced after the coming into force of the 2019 employment law, which is brought more than 6 months after the relevant employee's termination date. Any employee who had not commenced a legal proceeding, this is under the 2005 law, within 6 months of termination of his or her employment by the time the 2019 law came into effect, would not be able to have it considered by a court. So that in that case, you had claims which preceded the new law, but which were brought after the new law came into force and therefore applied. The evident purpose of the provision is to pick up employees who may be, as it were, resting on their rights to gain the benefit of the penalties claim which might accrue following the termination of employment.
Yes.
But the important point really is the stressor on would not be able to have that claim considered by the court. The question goes to the court's fundamental power, jurisdiction, however you want to frame it, to hear provision, whether it's being pleaded as a defence or not. And so in light of that, the relevant point for Your Honour, of course, is that the claimant's employment here was terminated on the 23rd of March 2022, and his benefits were paid out to him 2 days after that. This claim wasn't issued until 10 months after that date. So the issue date on the claim form is the 26th of January 2023. And before one even gets into the evidence, that's the end of it. The court has no discretion to consider the claim. And I'll deal with it in more detail during closing, but there's no, even if you apply what would in law be the wrong analysis, but if you're as generous as you can possibly be to the claimant about every factual issue and legal issue, you can't get it within the window. On any analysis, the claim ends up being out of time. And our position is the correct analysis. You take the date of termination, you add 6 months. And if you're not in, that's that. As I say, I'll come back to that later and in more detail. The second broader issue is on termination for cause. And I will take Your Honour briefly to some of the relevant statutory and provisions in case law, because it's important from the point of view of fixing one's mind on what the relevant question is as to whether or not the defendant acted reasonably in doing what it did. So the statutory provision is Article 63 of the Employment Law, it's page 736.
So what page?
736.
Thank you.
Towards the bottom of that page, so 63 1, which is an employer may terminate employment with immediate effect for cause in circumstances where the conduct of one party warrants termination and where a reasonable employer would have terminated employment as a consequence thereof. Now, this obviously isn't a particularly rigid or thorough set of statutory provisions as one might see, for example, where in the UK you have a very lengthy and complex set of statutory provisions dealing with unfair dismissal, procedurally unfair dismissal, and so on. We're not in that sort of territory here. These are broader common law principles. They were summarized quite helpfully in another one of the EXPRESSO cases. This was the Rahmtala case before the Court of First Instance, which Your Honour will find at page, the judgment starts at page 955. The relevant extract of it is at 964. And it's yet another endorsement of Mr. Reid and Mr. Montague Smith's Blue Book summary of it. But it says, termination for cause is, this is paragraph 39, I should say. As set out in DIFC court practice, termination for cause has been considered in a number of cases. For the present purposes, the following extract suffices. And then it refers to the Macduff case, where Justice Giles held there are two limbs. Whether an employee's conduct warrants termination, and 2, whether a reasonable employer would have terminated the employee. And it refers further then to an extract of the then Chief Justice in Leeson Lesko, which says the first stage of the test is akin to that which is applied at common law for summary dismissal and does involve some conduct which was fundamentally inconsistent with the employment relationship, seriously incompatible with it, or repudiatory of it. The second stage of the test involves a positive finding as to what a reasonable employer would do, and in that respect is distinct from the unfair dismissal cases in the UK. So the first limb of that comes back to, I suppose, the broader observation I made of the defendant's analysis of this case, which you can't have your senior accounting professional handing over money without getting documents. That is something which we say goes to the core of what he's being employed to do. And to put it in analogous terms, when one considers a commercial contract where you have a repudiatory or fundamental breach for doing something that is just inconsistent with what the basis of the contract is in the first place. As an accountant, you are there to ensure there is proper accounting of transactions, and it's the failure here that we say warrants termination. As to what is meant by a reasonable employer, there's probably a little bit more gloss one can gather from that in the Macduff case itself, which I'll pull up one paragraph for Your Honour at page 1016 of the bundle.
Yes.
And it's at paragraph 23 in the middle of this page, which says the construct of a reasonable employer must be given content. It's not a hypothetical employer remote from the particular circumstances and armed only with the knowledge of the conduct warranting termination. It's an employer in the circumstances of the actual employer, and the question is whether that hypothetical employer would, as a positive conclusion, have terminated the employee. So what Your Honour will need to do in considering the evidence is to take all of the relevant factual circumstances the defendant was placed in, the information it had at its disposal, the investigations it undertook, and so on. And then from that set of circumstances, ask what a hypothetical employer put into the same circumstances would have done, and whether they would have terminated the claimant's employment in those circumstances. And it's in that context then that Your Honour is going to consider the evidence about the specific transactions at the heart of this dispute, the investigations that took place once they came to light, and the conclusions that were reached. And the defendant's position, of course, is that quite reasonably, in this set of circumstances, sought a second external opinion of the claimant's conduct, concluded that the claimant had acted improperly and acted as a reasonable employer in ultimately reaching the decision to terminate the agreement. Closely related then.
Is it relevant, or does it matter that Mr. MOORKATH was not given an opportunity to answer or provide any information about the 2017 transaction?
Well, we would say no. So I mean, that's sort of, I suppose, to put it in UK parlance, that's the sort of thing you might think of if you were an English employment law practitioner as a procedurally unfair dismissal. So there you have causes of action in the UK where you can have unfair dismissal and a procedurally unfair dismissal, which a claimant could go to an employment tribunal and say, well, even if your decision would have been the same had you interviewed me or not, there's still some token allowance that is made if there's procedural unfairness. There's no equivalent in the DIFC. The question is,
right, if that's right, is the Parker Russell investigation completely irrelevant?
It's not. Well, I don't think it's irrelevant in any way, because it also deals, of course, with the 2016 transaction. The position is that either one of these transactions would have been enough to justify dismissal in isolation. There doesn't need to be some cascade effect. But what the Parker Russell report does on our analysis is it provides comfort to what the internal investigation had already concluded. So we have an internal investigation which concludes that there's been improper accounting in relation to these transactions. That's referred for a second opinion to Parker Russell, who come to the same view, and it reinforces the submission we will make, which is that the defendant in these circumstances therefore acted reasonably in following not only its own conclusions, but the conclusions which were actually supported by an external consultant as well. And that were one to plonk the hypothetical alternative employer into those same set of circumstances, they would have followed the same approach. Coming on to the third issue of law, which is they're closely related issues on the facts, but it's the counterclaim in negligence. There does appear to be a dispute around the legal framework here. The claimant's position is that there isn't such a duty in the employment context, and I'll deal with that fully in closing. But the first provision I was going to take your honour to is one that my learned friend flagged but couldn't find.
Can I give you notice of this, Mr. Doherty? It would assist me when you come to close your case, if you're able to cite to me one authority, or better still, more than one authority, where an employee's conduct or employee's wrongful conduct, which might amount to negligence, where that has caused pure economic loss to the employer, and the employer has recovered in negligence from the employee the amount of that pure economic loss. You may have cited, I haven't seen any case which fits into that category, which is this case.
Your Honour. Yes, Your Honour, I've got that point. I'll take you to the provisions I was going to go to, and you can decide whether or not that's gone far enough. But I've got notice of your point. Yes. The first provision is the one that my learned friend was looking for in the employment law itself. It's at page 731.
Yes.
And it's Article 58, which is where we find this statement of general duties of employees. So an employee shall, so you've got faithful service, comply with the employer's reasonable lawful instructions. The principal one here is C, really. It's exercise reasonable skill and care in performing their duties for their employer.
I think, Mr. Doherty, to take a line you referred to earlier, an English employment lawyer would probably say that all of those duties are duties implied in a contract of employment without any statutory requirement.
Yes, and there are various provisions of DIC law where we do effectively what is being built in is spelling out an assumption that can apply in many common law jurisdictions. So the other example in an employment context is if you go to the law of obligations under fiduciary duties, there's an assumed fiduciary duty as between an employee and an employer. And that's not the pleaded basis of the claim here, but that's another example of this sort of...
The reason I make that point is going back to the point or question I asked you earlier. It seems to me for the moment that the fact that those duties have got a statutory base doesn't differentiate the position from, if I can call it, the English cases.
Yes, and what I would take your honour to is, well, what we have said, I think, is an extract of a general principle of law at page 1050. So this refers to a case. The case itself is in the bundle, and we can perhaps revisit it during closing. So the case is Century Insurance and Northern Ireland Transport. This is an extract from Charlesworth and Percy on negligence, and this is dealing with the liability of an employee to an employer. And so this quotes the extract from Century Insurance. So I think it's a mid-20th century case. So the duty of a workman to his employer is to conduct himself in doing his work is not negligently to cause damage either to the employer himself or his property, or to third persons or their property, and thus to impose the same liability on the employer as if he'd been doing the work himself and committed the negligent act. This may be too obvious as a matter of common laws to require either argument or authority accordingly. And this is the text from Charlesworth and Percy, of course. The employee owes the duty to take reasonable care as regards the employer. But unlike the similar duty in tort between fellow workers to one another, it's deemed to be an implied contractual obligation arising out of the employee's contract of service. So probably that is similar in this context to the fact that it's been spelled out in statute, that you've got this implied duty of acting with skill and care. And what we would say is that in that context, if you don't act with due skill and care and you act negligently and you cause a loss to the employer's property, that the law can impose a liability on you for that. And it's not just about your interactions as an employee with third parties.
That's not this case, is it? This is not a case of damage to the employer's property.
It depends how one takes the, how does one view $1 million in cash in an account? It's the employer's property. In the same way that smashing a window is the employer's property, it's just a different type of property, we would say. And so we would say that it does cover the case of economic loss. We would say that the similar, again, this isn't the set of circumstances that we're in, but the same analysis would apply to a breach of fiduciary duty causing that economic loss under the law of obligations as well. And so what we say the questions Your Honour is going to be cognizant of is, what role was the claimant employed in, and what were his responsibilities in carrying out that work? What would an employee exercising reasonable skill and care have done when asked to effect the transactions in this case? And that, we say, isn't going to be informed by a number of things: policies, customs when it comes to payment requests, and statutory requirements, which we'll go through during cross-examination. And ultimately, whether or not the claimant's conduct failed to live up to that standard, and that's what was causative of the loss in this case. And the defendant's position here is that the claimant's failures in carrying out his employment were fundamental to the purpose for which he had been hired, and the loss is occasioned here by a failure to adhere to basic accounting procedures, which of course is what he is in his job to do in the first place. And Your Honour, once you analyse the case through this framework, we say much of the remainder either falls away or can be relatively easily disposed of. So, of course, all of the claims in this case are impacted by limitation. That might be as far as you need to go. The notice pay and gratuity claims turn on your view of whether or not you find that it was reasonable for the claimant's employment to be terminated for cause. The claims for education allowance and airfare turn on relatively narrow points of construction of the contract, but also provisions of the DIFC employment law. So you'll hear from me on that largely during closing. The loss of earnings claim, we say, has no basis in law and as such cannot be a valid cause of action in the DIFC because there's no statutory footing for bringing a private law action for the failure to cancel a visa. It's a regulatory matter and the employment law is pretty clear on that. And then the penalties claim, as well as being what the Court of Appeal would have termed as granting an impermissible windfall for the claimant resting on his rights and producing his claim late, it falls away in any event because penalties claims are parasitic on the other claims, which we say are misconceived and will be dismissed anyway. So unless there's any of that which I can be of assistance in clarifying further at this stage, that's all I'm proposing to say. You'll of course hear from me in more detail about that during closing.
All right, well, thank you very much, Mr. Doherty. Mr. Costello, I think we're ready for the claimant to give his evidence.
Yes. May I ask Mr. Moorkhath to switch on his camera and unmute himself as well, please? Sorry, I'm good. Yeah. Okay.
Okay.
There he is. Okay.
And can I ask the court officer to administer the oath, please?
Of course, Justice Lemiere. Good afternoon, Mr. Moorkhath. Mr. Moorkhath, could you please state your full name and address for the benefit of the court record?
FAIZAL BABU MOORKATH, Dubai.
Wonderful.
If you need,
thank you.
Yeah, okay.
Thank you, sir. And Mr. Moorkhath, I understand that you wish to give your evidence by swearing on the Holy Book today. Is that correct?
Yes.
Okay, wonderful. And do you have a copy of the Holy Book with you?
Yes, I have.
Wonderful. If you could please take that in your hand and raise it to the camera, sir, so that the judge can see. Wonderful. And if you can please repeat after me.
Okay.
I swear by the Almighty God.
I swear by the Almighty God.
To tell the truth.
To tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you, Mr. Moorkhath.
Yes, thank you, Ms. Norton.
Thank you.
Yes, Mr. Costello.
Thank you, Your Honour. I think it's a good afternoon, Mr. Moorkhath. You're in Dubai, I take it, yes?
Yes, yes, very good.
Okay, so we've got people from around the world today, so we're covering many time zones. Yes, so you are the claimant in these proceedings, is that right?
Yes.
And you have provided the court with a number of witness statements, but for trial, is it right that you have provided a third witness statement? Is that right?
Yes.
And a fourth witness statement?
Exactly.
And the fourth witness statement acted as a reply witness statement to the defendant's witness statements, yes?
Exactly, yes.
Okay, I'll take you through those in a moment. Just one more point of housekeeping. We've got a number of characters, entities, etc. You are obviously the claimant, but we have EXPRESSO Telecom Group Limited, that's the defendant, right?
Yes.
And we've got another company called Sudatel, I forget its full name, but the point here is Sudatel is the company in Sudan, which you have said in your evidence is the parent company.
Yes, parent company.
And in terms of references, it might be easier if we just refer to them as EXPRESSO and Sudatel as opposed to defendant and sort of tell any other names that may come up, just to keep things clear, okay?
Okay.
Okay, now, in terms of your witness statements, do you have the bundle in front of you?
A bundle of?
Do you have the trial bundle in front of you?
Yes.
Okay, so page 60 of the trial bundle.
1 second.
Sure, take your time. Excuse me.
Trial bundle, 1 second.
Yep. In terms of navigating, you might see.
But I don't have the trial bundle. Are you talking about the skeleton argument or
No.
trial bundle separate?
There was a link that you would have received from the registry that would say case bundle, etc. That will take you to the trial bundle. Do you have that email? If you don't, then the quickest thing to do is for me to just...
I received the notification, but there was no link actually.
Okay, let me see if I can just quickly send it back to you. Sorry,
Okay.
just bear with me one moment. Share. Okay. Right, you should now have in your emails your personal account
I'm
a
still
link
waiting.
that will take you to the bundle.
I'm sorry, I'm still not received. I'm waiting.
Do you have all the documents in this case in terms of the witness statements, exhibits, all the documents?
Yes,
Okay, what we'll try and do is if there is a particular document that you need to see, we'll put it on screen. But I think what we can do is give the judge the page reference and you can just pull out that document,
Sure.
which should be the same. But again, if there's any issue, we'll deal with it as it comes. But I'm conscious I don't want to keep the court waiting.
Your Honour, I was conscious that you'd suggested 15 minutes break now.
Yes.
Anyway, I'm aware that the witness has been sworn. He hasn't been asked a question by me yet. I don't think that there's any issue from my perspective of the lawyers talking to him. Could we use the 15 minutes to get him up and running?
Yes, thank you very much. I appreciate that.
I think that's a good idea.
Yes.
It is now, where I am, it is 5:13. I think it must be 1:13.
Correct.
In Dubai. We'll resume on the half hour. So 1:30 in Dubai, 5:30 my time. And I think that makes it for you, Mr. Doherty, 9:30?
Yes.
Yes. All right. So we will now adjourn and we will resume at 30 minutes past the hour.
Thank you.
Thank you, Honour.
Thank you.
Yes, thank you. Now,
Yes.
Mr. Costel,
Yes.
have you or somebody been able to sort out the bundle issue?
In typical fashion, as soon as we logged off, within a minute, it was resolved. So
All right.
it's sorted
All right.
now.
Well, you can start.
Yes, thank you. Right. So, Mr. Moorkhath, can you just please unmute yourself? You're still on mute. Sorry.
Yes.
Yes, thank you.
Okay.
And as you should now be familiar, there is a search bar in the bundle. Can you please go to page 60?
60, yes.
Yes, please. Just tell us when it comes up.
Third witness statement.
Perfect. That's your third witness statement, isn't it?
Yes.
And there is a signature which appears on the final page of that witness statement at page 104. Is that right? That's the
Yes,
signature.
that's my signature. Yes.
Okay. Before we deal with the formalities there is a typo which I think needs correcting in paragraph 138 of the bundle, page 100. So it's not it shouldn't be controversial. So if you just go to page 100 of the bundle.
100.
Yes.
Okay.
And if you turn to paragraph 138.
Yes.
You'll see that what you're dealing with there is the late cancellation and the loss of earnings. And then you conclude with saying until the commencement of employment, which was on the 6th of November 2023. I think you meant 2022, is that right?
Yes, it was
Yes.
2022.
Yeah. So other than that, that's the only correction, is it, that you wish to make to your witness statement?
No other correction.
Yes. So then your witness statement, as we say, as you confirmed, concludes on page 104, and you confirm that was your signature. Is that right?
Yes.
And there was a statement of truth which also appears on your fourth witness statement, and it reads as follows: I believe the facts stated in this witness statement are true to the best of my knowledge and belief.
Yes.
So do you confirm that the contents of your third witness statement are true?
I confirm.
Now, in terms of the formalities for the fourth witness statement, can you please go to page 115 of the bundle?
115. Yes.
Again, this is your fourth witness statement, is that right?
Yes.
Thank you. And if we go to page 128.
Yes.
That is a signature. Is that your signature?
That's my signature.
And again, do you confirm that the facts stated in your fourth witness statement are true to the best of your knowledge and belief?
Yes.
Thank you. Your Honor, I ask for those two witness statements to stand as the claimant's evidence in chief.
All right, well, I will take the third witness statement of the claimant as read, and will stand as the evidence in chief of the witness, and the exhibits referred to in the statement will be received as exhibits bearing the numbers and numerals that they bear in the witness statement. Similarly, for the fourth witness statement, I will take it as read and receive it as the evidence in chief of the witness, together with the, I don't think there are any, oh yes, together with the exhibits, if they're not already received in the third witness statement, they will be received in evidence and bear the numbers and descriptions they have in the witness statement.
Thank you very much, Your Honor. Mr. Moorkhath, I don't have anything further for you, but please wait there. You're going to be asked questions by my learned friend.
Okay.
All right, so Mr. Moorkhath, now Mr. Doherty, who is the counsel for Expresso Telecom Group, will now ask you some questions.
Sure.
Mr. Doherty.
Okay. Okay.
Thank you, Your Honour. Good afternoon, Mr. Moorkhath.
Very good afternoon.
I just wanted to start by asking you some questions about your role with Expresso Telecom and the DIFC. And in your witness statement, you explained that you were initially employed by Expresso as a senior accountant, and it's then from 2017 you become the director of corporate finance. So again, just to make sure I've got this right, I think what you're saying is that in 2016, when we have the first of the two transactions, which are the subject of this case, you were in your senior accountant role, and then for the second in 2017, by that time, you'd moved on to be the director of corporate finance. Have I got that right?
Yes. I was senior corporate accountant in 2016. Then I promoted to director in 2017.
Thank you. And I'm going to refer to various bits of your witness statement. Invariably, it's going to be your third witness statement. So if I refer to a paragraph, just so you know, that's what I'm referring to. And if you can go to at page 67 of the bundle and at paragraph 24 of your witness statement. So paragraph 24 begins on page 66 and carries over, but it's the last
paragraph.
It's paragraph 24, and it's the final bit of the final sentence that I'd ask you to look at. So it's at the very top of page 67. You say, from the 1st of November 2015 to December 2018, I was the only person in the finance department carrying out the accountancy duties. So either way, whichever role you were in, whether you were the senior accountant or whether you were the corporate finance director, it's right, isn't it, that you're the sole person within EXPRESSO that's responsible for what you say were accounting duties? You agree?
No, actually, till 31st of October, I was reporting to the Director Corporate Finance. Then a company transferred the director to another subsidiary. So from 1st November 2015, I was the only person in our office in finance department.
Yes, so I think we do agree. So
yes,
regardless of what your job title is, you're the only person in EXPRESSO who's doing these accounting activities.
Yes.
Yeah, and so presumably that would mean in both roles, you're responsible for, to give you the sort of general statement, things like generating accounting entries, maintaining accounting records, performing reconciliations, assisting auditors, things like that. That's you.
For EXPRESSO Telecom, yes.
Yes. You then go on, if you scroll down in your witness statement to paragraph 32, which is, it begins at the bottom of page 69, but most of it is in page 70. You go on to describe some of what you say were your responsibilities. So this is since the 1st of November 2015. So this is from the point in time you're EXPRESSO sole accountant. And if we look at A, on page 70, you say handling the defendant's office standalone accounting, including data entry to reporting. So presumably what you say at A there reflects what we've just discussed. You're the individual solely responsible for EXPRESSO's accounting, yes?
Yes.
And when you say standalone accounting there, again, please correct me if I'm wrong, but presumably what you mean by that is you're dealing with EXPRESSO's accounts. That's what you're concerned with. So you're their accountant and Sudatel has its own accounting function.
Yeah, standalone means we have Dubai office as a standalone, and we have subsidiaries, and we have parent company. So I was doing standalone accounting.
So does that mean your focus is accounting for EXPRESSO?
EXPRESSO, yes.
Yeah. If we then look at paragraph G, also on page 70.
Yes.
What you seem to say there is that the standalone accounting that you do for EXPRESSO is then something which is relied upon by the parent company. So if you look at what you say at G, one of your roles is intercompany reconciliation for the defendant. Once I recorded the transactions for the defendant, so that's EXPRESSO, the accountant for Sudatel and other subsidiaries would also record the transaction, you say, based on my intercompany record with supporting documents. In other words, the STG intercompany transaction was recorded by STG's accountant, not me, based on my record created for the defendant and with the supporting documentation provided. Just breaking that down into a couple of points, if I can. So first, if we have this sort of intercompany record, just in terms of the sequencing of this, what will happen is, first, you will account for the transaction on the EXPRESSO side. Is that right?
Yes.
And part of that would then create the record for EXPRESSO, which you say includes getting supporting documentation for that particular transaction, yes?
if I create any accounting entry, then I have to provide supporting document to Sudatel.
Yeah. And then you would provide the record and the supporting document to Sudatel's accounting function, who would then use that information to record the transaction on their own books. Is that right?
I record transactions only in EXPRESSO or ERP. The subsequent entry for Sudatel that will enter by Sudatel Finance Department.
Yes, but it's this bit. So what you say, based on my intercompany record with supporting documents, it's recorded by the STG accountant. So what you're saying is you've got your entry, you've gathered the supporting documents, and then Sudatel will use the information you have collated to create its own intercompany record. Yes?
Yes.
And so given what you explained there, would you accept that the record that Sudatel's accountant ultimately comes to produce is dependent on the records that you have kept in the first place?
Sorry, I couldn't get the question.
Okay, so we've worked through it. You create the entry, you gather the supporting documents, and you then provide that to Sudatel, who generates its own accounting entry. So the Sudatel accounting entry is therefore dependent on the information that you have gathered in the first place. Do you agree?
Yes.
So just working the logic through on that, if whatever you have recorded or the information you have gathered is wrong or incomplete, then whatever Sudatel subsequently record would also be wrong or incomplete.
No, that's why we are doing the reconciliation. If I give any wrong information, of course, they will ask for the right document. Without proper document, they cannot record any transaction in their ERP.
So I'm just writing that down. Let's take a hypothetical example. So if you were to have provided them information that was wrong or incorrect, contained some kind of material inaccuracy, if they relied on that, they would still be dependent on the records you've provided when they produce their own accounts.
Normally, during the reconciliation, they will ask many questions. If they have not enough document, of course, they will ask for the supporting document again. So that is the reconciliation process. Every month is going on, monthly basis.
Yeah, but really the point here is that whatever they get depends on you, doesn't it? So when they're reconciling this transaction and they need a supporting document, it's ultimately you that has to give it to them.
Yeah, that is the first document I will give. And if they require more document related to the same transaction, of course, they will ask during the reconciliation.
Okay. Sticking, if I can, on some of these themes around the general accounting process, if we jump forward slightly to paragraph 66 of your statement, so that's page 82 of the bundle.
Paragraph 66.
Yes. And this is in your section where you're dealing with the 2017 transaction, which I'm going to come back to and deal with the specifics later. But this is just a general question surrounding the accounting process.
Okay.
And what you say at paragraph 66 is the 2017 transaction was a normal transaction, and we followed the normal procedure of a Sudatel intercompany transaction. There was no abnormality, and I believe I forwarded the related supporting documents to Sudatel. So it seems to be what you were saying there, as I understand it, is consistent with the evidence that you've given so far, which is a normal intercompany transaction is one which you would expect to have been accompanied by supporting documents explaining the nature of the transaction. Is that fair?
Yes.
And so would you accept as a general premise, as a, I suppose, a core principle of accounting, that when you create accounting entries, one of the things you need to do to ensure, one of the things that you need to do is to ensure that you've got adequate supporting evidence or underlying source documents which explain the particular entry?
Yes.
Can I ask you to have a look, please, at page 1105 of the bundle? And just to give you a bit of context while you load that up, this is a provision of the DIFC Companies Law 2009. And the reason I'm taking you to this document is to try, and as part of this understanding of your role, understand the regulatory framework in which you were performing your role for EXPRESSO. So as you can see at the top of this, this says Chapter 2 Accounts. So it's the section of the company's law dealing with the company accounts for a DIFC entity, which of course EXPRESSO is. And if I can ask you, first of all, to go to the bottom of this page and look at 103, Article 103, right at the bottom, and which continues over the page. It says, the managers, or the directors or managers of every company shall cause accounts to be prepared in relation to each financial year of the company. And then 2 over the page says the accounts shall be prepared in accordance with accounting principles or standards. B, show a true and fair view of the profit or loss of the company for the period stated. Now, I realise, again, this is quite a general question, but given your role, given that you're EXPRESSO's sole accountant, presumably you would have had an understanding that one of your functions on behalf of EXPRESSO is to make sure that its accounts were prepared in accordance with both the accounting principles and standards, as well as that they provided a true and fair view of the financial position of the company. So I see you nodding. This is solely for the record, but you agree with that?
Yes, yes, I agree.
And if we look, for example, at Article 103.4, which is further down this page, Part B, it says within 6 months, at the end of the financial year, the accounts for that year will be examined and reported upon by an auditor. So again, and you're obviously part of the internal accountancy function, but you would have been aware that EXPRESSO's accounts would have been subjected to external audit.
Yes.
Do you agree?
Yes, yes.
And so presumably when you prepared company accounts, you were mindful of that. Would you agree with that?
Sorry, the last question.
So presumably when you're doing your work and preparing the company's accounts, you would be mindful of the fact that in due course, someone may need to carry out an audit.
Means I will prepare for the audit, right? Within 6 months.
Yeah, but even when you're preparing any accounting entry, you will have in mind that an auditor might need to look at a particular transaction down the line.
Yes, yes. So auditor will prepare this all accordance with the accounting principles and standards. Okay.
If you could then scroll back to 1105 up at the top, we've got Article 101 of this law, and this provision deals with maintenance of accounting records. And what it says is that every company shall keep accounting records which are sufficient to show and explain its transactions so as to disclose with reasonable accuracy the financial position of the company at any time, and to enable the directors or managers to ensure that any accounts prepared by the company under this part comply with the law. Now, again, this might strike as being pretty basic stuff, but I have to ask you whether, as EXPRESSO's only accountant, you understood the requirement placed on the company to maintain these accounting records.
Yes.
Yes. And what this provision says is that those records need to be sufficient to show and explain transactions with reasonable
Yes.
accuracy and at any time. So, I mean, I guess just to put that in layman's terms, presumably the ideal standard you want to be getting to is that you can pick any particular transaction in the company's accounts. You can go and look at the supporting evidence, and that will help you discern what this transaction is about based on those documents. Is that a fair summary?
So you start asking about 2017 transaction, right?
I'm going to come to that later. Really, this is just about,
Okay.
in general, what do you want from a set of accounts? And when this law says that the records have to be sufficient to show and explain transactions at any time, what we would want is, if, let's say I'm an auditor, I go into the company's general ledger, and if I look at a transaction, I want to be able to say, well, let me go look at the documents supporting, the source documents supporting this transaction. You can go to those, and effectively you can unwind or read the documents and understand what this transaction is.
Yes.
Yes.
Agree.
If you can skip forward in this same document to page 1140.
Sorry, the page number
1140.
1140. Yes.
This is a section, it begins with bullet point number 3. It sets out some of the defined terms. So in the provision that we've just looked at, the term accounting records has a specific definition, which we can see here. And if you look at the table, which is the bottom of 1140 and carries over to 1141, what it says is that the term accounting records means records and underlying documents comprising initial and other accounting entries and associated supporting documents. And then it gives some examples you see there. So it says checks, records of electronic funds transfers, invoices, contracts, general and subsidiary ledgers, and then worksheets. And again, my apologies if this all comes across as being quite basic, but it seems to me that there are two elements to this. So if one looks at E and F, there is the record that is kept of this by the company. So that's, for example, what has been recorded in its books or in its ledger or in journal entries. Yes?
Yes.
And the second part that this provision deals with is also what it calls the underlying or supporting documents. Yes?
Sorry, what is the second question?
So, for example, if we look at the things that are listed at A, B, C, and D here,
Yes.
those are what you would describe as the underlying documents. So those are the source documents, invoices, and basically the paper trail, which shows that this is a legitimate transaction and this is what the transaction is. So that would be the second part of what comprises an accounting record. Do you agree with that?
Yes, I agree.
So as an accountant for a DIFC company, would you agree that part of your job must have been ensuring that for every transaction, you have a proper paper trail or evidence which explains what the transaction is?
Yes, I agree with that. If any transaction, there must be some supporting document as explained in the DIFC company law. Yes.
Coming back to your witness statement, if you go to page 89, and at the bottom of this page at paragraph 98,
yes,
we have this first sentence. You say, there were no policies or procedures that were applicable to how to act in the situation that I was in. By just pausing to reflect on that, I suggest to you that it's not strictly correct, is it? Because of course you're a professional accountant, you're EXPRESSO's only accountant. So would you accept that ultimately part of what you are guided by are the relevant standards of practice that apply within your profession?
Actually, the question was, I break the policies and procedure of company. That was the investigation base. So my question, I am not, my answer is that I am not break the company policies and procedure. And I follow the company law. This is the standard which I already follow. There is no question about the standard procedure. But the investigation based on the company policies and procedure. That's what I came to know from the investigation.
Okay, so just to be, I suppose, slightly clear on that, I think probably you agree. So as a professional accountant, even if you don't have a specific EXPRESSO policy to know what to do in terms of keeping supporting documents, you still have and are informed by your professional training, professional standards, and the company law, yes?
Yes.
And indeed.
Yeah. But what I'm saying, I follow the company, standard procedure for accounting. I already follow the standard procedure for this transaction as well.
In that context, would you agree with me that as someone who's hired as an accountant for a DIFC company, part of what guides, or part of what would be expected to guide how you perform your role, would be the regulatory function you're carrying out for the company? So that's ensuring that their accounts comply with the law.
Yes, normally, the company policies and procedure should comply with the DFC company law.
Thank you. If I can move on to what we do have in terms of company documents, if you can turn up page 422 of the bundle, please.
$422.
Yes. Are you using a PDF or are you using the DIFC's court system? So just so I know, the court system can take a bit of time to load up documents, so I know how long to give you. Have you got that document at page 422?
Yeah, 422. I'm in 422.
If it assists my learned friend, he's using the DIFC bundle online.
Okay, we'll be getting there at the same time then.
Yeah.
So this should be a document in front of you which says Company Authorization Matrix, 29th of May 2008.
Yes.
And if we scroll down, first of all, to page 424.
Yes.
Just so we can properly interpret this, do you see there's effectively a list of abbreviations on this page? Do you see? So, for example, we have CFD about 6 or 7 lines down, which says Corporate Finance Director.
Yes.
So, that, for example, that's the position you would come on to take in 2017. If you go down towards the bottom half of this table, it says, do you see it says EXCOM? And that's the executive committee of EXPRESSO Telecom Group. Do you see that?
You're talking about the abbreviations, CFD,
yeah.
Yes.
Yeah, EXCOM.
Corporate Finance Director.
Yeah, so that's CFD, but if you go further down, it's in the middle towards the bottom of the middle. I can describe it that way. It says EXCOM, EXCOM.
EXCOM, Executive Committee of EXPRESSO Telecom, yes.
Yeah, and then 3 lines from the bottom, we've got STG, which is a separate abbreviation with the concerned party is Sudatel. Do you see that?
Yes.
And can you scroll to the next page, which is 425?
Yes.
We've got a slide titled Rules and Authority, saying upon its approval by the Board of Directors, the totality of the below authorization matrix becomes an integral part of the relevant company's bylaws and shall replace previous authorities. And then there's a heading that says Rules of Authorities with a number of numbered bullet points saying authorities are those limits set by the Board of Directors. The ETG Board of Directors may designate all or part of its powers or authority to a nominated committee or person, and so on. So by all means, take as long as you need to look at it. Would you agree with me that what this document is doing is specifying what level of approval is required within EXPRESSO in order for certain actions to be taken and authorized by the company?
This is the rules of authorities, yes.
And if we go over to page 426, we have some more definitions. Again, this is just to make sense of some of the provisions we'll come on to. But you see under definitions, it says approval is APPR. And approval means the authority to make a decision and to sign documents for a specific subject. So if it says APPR, that means that we're talking about the authority to make a decision and sign documents. Yes?
Yes.
Over the page, please, to 427.
Yes.
We have a section called creation of a liability. Do you see that at the top of the page?
Yes.
And we have a chain of different APPRs, so a chain of different approvals depending on the value of particular transactions. And do you see that there are the letters in the row that says above 500,000 euros?
Yes.
It says APPR, and if you look up at the column that it's referring to, it says XCOM. Do you see that?
Yeah, I can see that.
So what this is telling us is that if you're creating a liability within EXPRESSO exceeding 500,000 euros, you need to have the approval of EXPRESSO's executive committee.
That's correct.
And then if we go to page 435, we have a section dealing with disbursements.
Yes.
And at the top of the page, there are a list of what appear to be A signatures, B signatures, and C signatures. So, for example, we can see corporate finance director is B. So you would have been a B signature, is that it?
Yes.
And the A signatures would be, amongst other people, the CEO. And what it tells us is that if we look at this section 10B for disbursements, it says disbursements include signing of all checks and wire transfers approved according to this authorization matrix. And again, we've got different levels of financial amounts. But if you've got somewhere between 50,000 euros and €1 million, this suggests that you need an A signature and a B signature. Is that right?
Yes.
And I know that we talked about the role that you were in 2016 and that it was senior accountant rather than the corporate finance director. But I also understand that your evidence in relation to the 2016 transactions is that you were one of the signatures for the issuance of the check, which is used to acquire the dollar cash amount. So am I right in thinking that even though your title changed, in practice, this matrix apply to you still in 2016 when you're positioned as senior accountant? So you would have been the B signature in 2016 as well as in 2017.
Yeah, 2016 it was like a delegation of authority. So even though my designation was not director, but they can delegate me as a signatory.
Yeah.
As I said, I was the only one person in finance department.
Yeah,
so,
I was going to say that. Presumably that is on the basis, you're whatever your title is, you're the only person in this finance function.
Yes.
And so in order to release the payment, if it's above 500,000 euros, you need to get the A signature and the B signature.
This 500,000 euro you're talking about creating liability.
Sorry, yes, that's creation of liabilities. If you've got a transaction which is up to €1 million and you want to release that amount, you want to make the disbursement, you need the A signature and the B signature to do that.
Yes.
Is that right?
Yes, yes. For releasing up to 100,000, sorry, 1 million, 2 signatures are required, A and B.
Okay. Thank you, that's helpful. Okay, having dealt with that by way of framework background, what I'd like to take you to is some examples of how this all looks in practice. And maybe if we can start at page 160 of the bundle. Apologies if you have that already. I'm still waiting on it.
Sorry, are you waiting? Sorry,
I'm waiting for my my washing machine wheel to stop spinning so I can see the document myself.
Okay.
So, sorry, bear with me. It's the IT delay on my side. Okay, so what you should find at this page reference is an email chain to which you're replying, but we can see that there's the first message, which is sent on the 27th of July at 10:43 a.m.
Sorry, could you please give me the page number?
Page 160, 160.
Yes.
So if you look in the middle of this page, we see the original email from Menthad Building. Subject final invoice says, "Dear sir, please find the attachment herewith." And then you, in the email above, forward that email on, and you say your approval is required to pay 12,000 dirhams to Al Menthad Building contractors against their final invoice. You see that?
I can
and
see.
If you go over the page to 161, we find the invoice itself. Hopefully you should see there's it's a building contractor's invoice for 12,000 dirham.
Yes.
And so this is the invoice that you are requesting approval for, yes?
Yes, yes. This invoice under EXPRESSO Telecom name. Yes.
Yeah. And if you go to page 100 and apologies, I've got the wrong page reference there. 158, I think it should be.
158.
Mm-hmm.
Yes.
Here we've got a document which is titled Money Transfer Instruction.
Yes.
So we can see beneficiary name, bank account number, and so on, and how much it is. And you see at the bottom of the page, we've got two signatures. We've got your signature on the left, yes?
Yes.
We've got Mr. Rahamtala's signature on the right.
Yes.
And we've got the company stamp in the
Yes.
middle.
Yes, yes.
And over the page, again, at 159,
yes,
This is a document which says domestic wire transformation confirmation. Do you see that?
Yes.
Now, again, I realise that this is a long time ago, but it may well be that you recall it based on what your practice was at the time. If one looks at this document, do you see on the left-hand side, you've got what look like hole punches? So you've got the little rings on the left-hand side of the page, where you would normally punch holes and put this into a physical folder of some kind. Do you see those?
Page number. Which page number you're talking about?
Page 159. I'm still looking at this domestic wire transfer confirmation.
Yes.
Yeah. So if you look down the whole, look down the left-hand side of this page, do you see you've got two little circles on the left-hand side, which imply that this document was hole punched. Do you know what I mean by that?
Yes, yes, yes.
And so what that would suggest is that this is a document that someone has physically printed out. So, for example, if you look at the top of the page, it refers to page 101. And at the bottom right hand of the page, we've got the date, 27th of July. So am I right in thinking that this document, and in fact, if you look at all of these documents, they've all got hole punches in them. Am I right in thinking that the practice would have been to print this out, get the hard copy, stick it into a physical folder of some kind?
Yes.
So that's part of the accounting process. You print off these source documents, so I can call them that. You put them in a folder, and if you need to refer back to them, they're there. Is that right?
Yes, yes. We're keeping in file, physical file.
And again, just as a...
Let me put my charger. 1 second.
That's okay.
Okay, continue, please.
Yeah. And again, it may well be that you are unable to answer, but looking at the date that you see at the bottom right-hand side of this page, would that imply that you print these documents at the time of the transaction? So that says the 27th of July, 2017. So was your practice as an accountant when the transaction happens, there and then, you get the physical documents and the records and you put them into your filing system?
So, yeah. First of all, this particular transaction, it's related to EXPRESSO Telecom Limited. It's not related to Sudatel. And
yes.
If any transaction, as you said, we will print the physical document and we will kept in file.
Okay.
It's the normal practice.
Thank you. Sorry, it can sound when you go through questions like that like I'm trying to trick you somehow. No, I'm just trying to get an understanding of your process and how this all works. So just to kind of break it down, let me see if you can agree with me that the recording of this transaction seems to follow a number of steps. So first of all, you generate the email request seeking approval for the payment. Yes?
If it is related to EXPRESSO Telecom. Sudatel, it's different process.
Okay, I'll come on to that in a moment. Let's deal with it just from an EXPRESSO point of view for now. So you get the internal approval in this case from EXPRESSO, yes?
Yeah, for EXPRESSO, this is the process which we are following.
Yeah, and then the second is part of this request. You've also got here the invoice, which explains the application of the money, yes?
Yes.
Third, we've got this, what appears to be treated as a formal document, so the money transfer instruction. So that's got the A signature, the B signature, and the company seal, yes?
Yes.
We've got this fourth document, the domestic wire confirmation. So what that shows is that the payment has been made and received by the beneficiary, yes?
Yes.
And what you do with all of these documents is you print them off and store them in a physical file.
Yes.
And this is a process that you followed for a 12,000 dirham transaction.
Yes.
And again, just to perhaps build on that, if I may, if you can go to page 163.
Yes.
We can see what appears to be the same process again. So 163, here's an email chain. Dear Tariq, I request you to release my schooling allowance for the year 2017. And then we've got Mr. Rahimtalla's email in response to you saying approved.
Yes.
So here we've got, again, with the same hole punches and everything else, the documented approval of the payment, yes?
Yes.
At 164 over the page,
Yes.
we've got the money transfer instruction. So it's got the A signature, the B signature, and the company stamp, yes?
Yes.
If you go back slightly to 162,
162.
yeah,
Yes.
here we've got the wire confirmation showing that it's been paid and received, yes?
Yes.
And actually, in this occasion, it appears that we've got two signatures and the company stamp. Would that be the same signature as we had on the money transfer instruction? So is that you, Mr. Rahimtalla, and then the company stamp?
Yes.
Yeah. Who would actually apply the physical company stamp? Is that something that you have?
Yes. Yes. I'm putting this down.
Okay. And so this is similar process for what in this case is a 25,000 dirham transfer, yes?
Which transfer? 35?
So this one's for 25,000 dirham, I think. But I suppose the question is, you follow this formality even for a 25,000 dirham transfer?
Yes. But you can see there is a difference from the previous transaction. Previous transaction, we prepared the money transfer instruction and we both signed. And the Husham Suleiman transaction, of course, we sign on the domestic wire transfer. We follow different procedure.
Well,
but
actually, it appears you've got both, because I think we looked at the second of those, didn't we? So it's at 164 as the money transfer instruction.
Yeah.
Oh, sorry, apologies, that's the wrong page reference. It was, I took you to... So I'll come back to that, bear with me. Yeah, sorry, I see the, yeah, I took you to the wrong document at page 164, but I'll take you through that one now, because that's probably helpful. If you could stay on 164,
Yes.
You'll see this is the money transfer instruction. The beneficiary name here is Dubai National Insurance and Reinsurance. Yes.
Yes.
So signed in the same way. If you go to page 167, first of all,
Yes.
and 168, here we've got the email chain, don't we? So this is, so in the middle of page 167, dear Tariq, your approval is required to pay the insurance premium for Q2.
Yes.
We've got reference to the 71,000 dirham amount, and then we've got the email above that which says approved, yes?
Yes.
At 166,
Yes.
we've got the relevant invoice.
Yeah.
And then at 165, we've got the wire transfer form.
Yes.
So again, we've got the consistent set of documents that you've printed out in relation to these transactions. So if I can ask you to hold those documents in mind and turn up page 106, please.
168.
106.
106. Yes.
where you should have an extract from Mr. Abdul Malik's witness statement. And if we look at what he says at paragraph 6, he says EXPRESSO implements the following payment procedure, which is also followed by the wider group, which must be followed when making payments. So he says, first, the requester sends an email seeking approval from the concerned managers and directors according to the authority matrix, and that email will contain an invoice if the monies are being sent externally. 2, he says the finance department prepare a payment order once joint approvals have been received and verified. 3, he says that the payment is processed by a bank transfer to the beneficiary. And 4, he says a document confirming receipt of the amount should be attached to the payment sheet, so swift copies of receipts. And he refers to the examples. My question to you is whether you agree that what he says at paragraph 6 is actually consistent with the payment processes that we've just looked at.
This paragraph 6, this is first time I can see in a written format. I couldn't see this type of payment procedure in EXPRESSO, but somehow we are following that procedure. These 3 documents which we just discussed, all 3 payment related to EXPRESSO Telecom, we follow the same or similar procedure.
Yeah,
I can see there are some other transactions related to Sudatel. Maybe you will come to that point.
I will. So your evidence, at least up to this point, is that for EXPRESSO transactions, yes, it might not be written down in a formal policy, but this is the process you follow. Do you agree?
Sorry, this process?
So even if it's not written down in a formal policy, when it comes to EXPRESSO transactions, you agree that this is the process you followed?
For that 3 transaction, you know, in EXPRESSO, if we look up to more transaction, maybe we can see different procedure follow, because there is no standard procedure for the company.
Would you agree with me, at least, that documenting transactions in this way would be pretty consistent with what was required of EXPRESSO under the company law? So that is its requirement to maintain proper accounting records.
Yes, we have to follow that, at least the standard process. Yes.
And in fact, again, you can agree with me or not, but I suggest that this process we've looked at sort of makes sense in that context, because I suggest it tells us 4 things, doesn't it? So the first thing that this chain of documents shows us for the transactions is that the payment request has been authorized by the correct people. And what I mean by that is, if you're creating a liability for EXPRESSO, that someone has said you can do this. Yeah.
Means the approval process, right? You're talking about the approval process.
Well, I'm talking about the approval that the company is allowed to spend this money in the first place, putting to one side the method through which it's dispersed. So what you've got is the email chain, first of all, showing that the payment request has been authorized, for example, by the CEO. Yes?
Yes, for EXPRESSO, yes.
Yeah. Second, the documents retained show us that the disbursement has been released in accordance with the authorization matrix, because the payment has been, the payment and the form of the payment has been signed off by the proper people. So that's the A signature and the B signature.
Yes.
Third, when we look at what's in the accounting file, it tells us what the transaction is, because we have a traceable way of finding out what the money's being used for. So, for example, we've got the invoice from the insurance company, yes?
Yes.
And fourth, it tells us that the money has actually been received by the person it was meant to be paid to. So that's the purpose of the SWIFT confirmation.
SWIFT is not the confirmation from the beneficiary. SWIFT is the confirmation from our bank. The money has been dispatched.
Yes, what you have there is a paper trail which shows this money has been sent and this is where it has been sent to.
Yes.
coming on to the, I suppose, the Sudatel side of this, if we go to paragraph 39 of your witness statement, and when I say that, I mean your third witness statement, of course, is what we've been referring to. It's at page 72.
Yes.
You say, if any transactions related to Sudatel, all approval processes had to have been completed at Sudatel level, which would then instruct to facilitate the payment from the defendant company. And you say the following documents produced by the defendant are examples of this. And I'm going to come on to look through the documents I think you're referencing there. But I suppose before I do that, I think what you're saying here is if a payment is going to be made by Sudatel to, say, a third party, and EXPRESSO is being asked to be the conduit for that transaction by sending money from its account on Sudatel's behalf, then you need evidence that there was the relevant approval from Sudatel, and you would want a record of that. Is that what you mean? Yeah. And so if we can walk through the example that you give, which I think starts at 186.
106.
Sorry, 186, 186.
186, yes.
So this is, so if you look at the bottom of the page, we can see an email from a gentleman called Billy Shackleton.
Yes.
It appears to be sent to a number of Sudatel addresses, subject re open mind payment. We then have a response above that on the 11th July 2017 from sort of Mr. Amir Idris, Amir at Sudatel. So he says, can you please provide the below information to perform the money transfer?
Yes.
And so that's the supporting invoice, bank details, and so on. So when in your evidence you're describing this is an example of a transaction involving Sudatel, is what you mean that here we've got the Sudatel email address that is the one seeking the supporting invoices and so on. So the origin of this transaction starts with Sudatel, even if it eventually comes back to EXPRESSO.
Yeah, this is exactly an example of Sudatel transaction. So all approval process happening in Sudatel, not in EXPRESSO. Once they got approval, then we will get instruction to make the payment on behalf of Sudatel.
Okay, so really there's an extra layer here, which is that you need to see that there's the approval from Sudatel in the first place, and then you kind of carry out your payment process. Is that right?
Sorry again.
So here, where it's a Sudatel transaction, is your evidence that there's effectively an extra layer on top of what we've looked at, where you need the Sudatel approval. Once you've got the Sudatel approval, you can go on and process the transaction in your way.
Yeah, it's not basically the approval, instruction. You know, we depend on the instruction which we are receiving from Sudatel.
Okay, well, perhaps I might work through this open mind transaction. We can see if we scroll up further in this email chain to page 185.
85. Yes.
So we've got the reply from Mr. Shackleton. He says, "Dear Amir," and he provides the account details and the invoice amount and so on. And if you scroll up to the bottom of page 186, what then appears to happen is that we've got this Mr. Amir from Sudatel forwards this chain of emails to you on the 12th of July, saying, please below, I assume it means please see below and attach the required information. Yes?
Mr. Doherty, you said page 18, scroll up to 186. Did you mean to 184?
Sorry, I started on 186. I meant to scroll up to 185, and then I'm continuing to scroll up to 184. It's an email chain, so
Yes.
chronologically we're going backwards.
Yes.
But sorry, I might have given the wrong reference. So just to break that down again, 186, we've got Sudatel say, give us the invoice and the details. 185, we've got Mr. Shackleton responding saying, invoice attached, here are the bank details, here's the amount. And then at the bottom of 184, do you see there's the email which forwards this whole exchange to you, saying, please see below and attach the required information, yes?
Yes. So till 185, I'm not involved in any process. Till page number 185, I'm not in the email. So first time I'm appearing in the email in 186 page, 184.
Yeah. And then from 184, as we continue to scroll up, you then sort of take on the communications with Mr. Shackleton, dealing with foreign exchange and so on. So you're kind of picking up the payment at that stage, yes?
Yes.
So Sudatel here forwards you the request. You then are putting it into effect.
Yeah. See, if you go to page number 184, the first email which I am receiving, it's like, dear FAIZAL, please below find attached required information.
Yeah.
There is no instruction, there is no approval, but this is the process which they are following. Like, sometimes they will send email, then the further information they will provide by WhatsApp or by even telephone. So this document is the proof, the approval process is happening in Sudatel, and I'm the person receiving instruction to execute the payment.
Yeah. So let's work through the rest of the documents then on this, because this should hopefully help clarify how these processes interact with one another. So if you can go to page 178.
Yes.
First of all, at the bottom of this page, we've got a 6th of July email saying, Dear CEO, so that's to Tariq Hamza, Zainal Abdin, on 6th of July, says, Dear CEO, I've tried twice to reduce this payment. Please approve the payment of 60% of the advance of this amount. Do you see that?
Yes, yes. Mr. Sami
And
Yusuf
then
sent email to Tariq Zain. Yes.
And then on the 9th of July, we've got the response to that saying approved.
Yes.
And then on the same day, that chain is forwarded to you. Yes? That's the top of the page. We can see forward open mine payment. So this is being sent to you as evidence of the approval from Sudatel.
Yes. So till the approval process, I am not involved in the email. So after approval, I just got forward that email. That's all.
Yeah. So before making this a payment, you've at least got this email chain that says approved, coming from Sudatel.
Yeah.
If we then go to 177.
Yes.
This is the open mind invoice. So this would have been part of the chain that was forwarded to you as well, wouldn't it? So this is the evidence which shows us what the payment is actually for. Would you agree?
Yes, yes. For this particular transaction, yes.
And if we go to page 175.
Yes.
Here we've got the money transfer instruction.
Yes.
Sorry, bear with me. I think I've given you the wrong transfer instruction. So I put that on hold for just 1 second. Can you go to page 176?
76, yes.
Apologies, Ryan, my page references have gone out of kilter. I'm just going to have to dig to find these.
If my learned friend tells me what he's looking for, I might be able to help him as well.
So there is, as I understand it, in the bundle, the money transfer instructions for the 71,000 amount. But I'll revisit that and circle back to it once I've done out those transactions. But in any event, Mr. Moorkatha, what we have here, we've got the email chain showing us the approval from Sudatel, yes. And we've got the invoice for the amount.
Yeah, for this particular transaction, yes, they provide the email chain. And there is no instruction, but they just forward that approval, which they got it from internally from Sudatel.
Yeah. So what we have is a documentary chain telling us what the transaction is and that it has been approved by the relevant people. Yes?
Yes, I'm repeating for this particular transaction. You know, each transaction have different procedure.
Okay. So with that in mind, can we look on to the transactions which are the subject of this dispute? So we can see how what we have there compares to what we've just looked at. And of course, what we've just looked at are transactions which are, let's put it this way, an order of magnitude smaller than the ones we're going to come on to look at. If we can start, please, at page 156.
156. Yes.
So we've got here, this is the email from the 30th of May, 2016, from Mr. Rahamtala to you, transfer. Dear Faisal, please withdraw what equals 1 million USD in exchange from AED to USD, hand to Husham. These instructions need to be treated with a high level of confidentiality.
Yes.
So just as a starting point, would you accept that this is a substantially larger payment than the ones we've just looked at?
This was the starting point, and as per this email, it was very clear. Please withdraw what equal to 1 million and exchange from AED to USD and hand to Husham. Husham is my admin manager. There is no other instruction in this email. This is just arranging the fund of USD 1 million.
Yeah, and the first question I asked is whether you would accept that this is a substantially larger transaction than what we have looked at so far. I think the biggest transaction we looked at otherwise was 70,000 dirham, and this is bigger than that, isn't it?
Is there any question to me?
I think it's been answered. Let's look at the content of this email. So here we've got the instruction, withdraw $1 million, hand it over to somebody. There's nothing in this email that tells us what for, is there?
Yes, this time no.
It doesn't say, for example, this is a payment being made on behalf of Sudatel, does it?
In this email, no.
The email doesn't mention Sudatel at all, correct?
Yeah, in this email, no.
It certainly doesn't say this is a payment on behalf of Sudatel for this specific invoice, does it?
Yeah, this is only to withdraw and exchange to USD and give to Hisham.
So withdraw $1 million in cash, hand it to another individual for reasons that are unexplained and don't tell anyone. That's what this instruction is, isn't it?
Other person means it's handover to Mr. Husham. Husham is the admin manager, not to third party. This is internal. This is just an arrangement of cash.
Yeah, you're being asked to hand cash to any other individual, and this email instruction is telling you treat this with a high level of confidentiality, correct?
Yes, there is reason.
Is your evidence that this simply was something that didn't concern you or alarm you in any way at the time? That the idea of being asked to hand over $1 million in cash and keep it quiet?
You know, for me, this was like, normal process. Even before this transaction, sometime I'm getting instruction to arrange $100,000, sometime $50,000. So for me, this is similar transaction, but as you said, it's $1 million. That is the only difference. So normally we will arrange the cash, then we will get instruction what to do, how to do, where to transfer.
Well, I mean, as far as you're concerned, presumably by this point in time, this is something internal to EXPRESSO, because we don't know of any involvement of Sudatel at this stage, do we?
Yes, during this time, in this email, no.
And we've looked at evidence when it came to a 12,000 dirham building contractor payment previously. And when you were asked to do something with that, you were sent the invoice and you liaised with other members of staff to get signatures and so on. But again, considerably bigger payment, but there's not really any of that here, is there? You're not being told any application of this money, are you?
Yeah. You know, in this stage, we are not creating any liability. All other transactions which we explain, Almendat, insurance, all other approval process happening inside EXPRESSO to create the liability. That expenses belongs to EXPRESSO. In this stage, we are not creating any liability. From our bank account, we are withdrawing some cash and keeping the cash for further instruction. That's all.
It doesn't say that, does it? I mean, the implication of this email is that the money's going to be used for something. Otherwise, why would you be asked to keep it confidential? Obviously, the money's not just going to sit around in the office and be used at someone's desk. If you're being asked to keep it confidential, surely when you read this, you thought, well, this money is being used for something.
Yeah. During this stage, for me, in this email, I cannot explain, but of course, once I receive this email, of course, I will ask to Mr. Tariq Rahmatullah what this is for what. So the answer is that he received instruction from Sudatel. So for me, as my reporting manager, Mr. Tariq Rahmatullah, giving an instruction to withdraw the amount and exchange to Mr. Husham, this is nothing unusual for me.
And chronologically, it's right, isn't it, that on the very same day you get this instruction and you don't ask what's this for, you put in the first of the sets of transactions with the Wall Street company and ask them to exchange it. So the first time you do that, I think, is you draw up a check on the 30th of May, yes?
Yes, yes. You know, after receiving this email, there are a lot of communication happening in between. Like maybe it's not in the email. We are sitting in the same office. So the discussion is going behind the scene. So I can understand that instruction is come from Sudatel. We need to arrange the cash. Then we will wait for the further instruction, how to utilize the money. And one more thing, well, this all cash, all fund belongs to Sudatel, not EXPRESSO.
Well, I think that the defendant disagrees with you about what you say there. But even putting that to one side, you accept there's nothing documented explaining what this money is supposed to be used for?
During this email, no documents has
all we
been
have.
attached.
Yeah. So putting aside whatever conversations you say you were having, which I say we don't accept, do you agree that in receiving this instruction, you are still acting for the company as its accountant?
I'm acting as
you're a company accountant, yes?
Yes, yes.
So presumably you would have been mindful of, amongst other things, the company's needs to present its financial statements, its financial position fairly and correctly, and to support the accounts you keep with proper records, yes?
Yes.
And you never, in that context, respond to Mr. Rahimtallah saying, yes, of course I'll get the money. Can you please send me the supporting documents so that I can put these on the file showing what the transaction relates to, correct?
Not exactly. During this stage, as I said, we are not creating any liability. But while entering any transaction into system, of course, we need the supporting document.
Well, when you say you're not creating a liability, you're signing a check for over 3 million dirhams,
Mm-hmm.
and you're handing it to a third party. So that's Wall Street, yes?
Yes.
Who are going to encash the check. Is that not something that's relevant from an accounting perspective?
Yeah, creating liability perspective, it's not creating any liability. This is like, exchanging cash from bank to cash, petty cash even. So in our record, we are not creating any liability.
And so does the company keep records of what amounts of money it stores in different currencies? Is that not something one would expect? We've got this much in USD, we've got this much in dirham in an account. Not relevant to document that?
No, for us, before it was in bank account, now that cash moved to the cash, petty cash. During this stage, there is no liability creation.
All right. What did you think when you were being told to keep this confidential?
Confidential in the sense, sometimes we are receiving huge cash from our subsidiary. So I'm receiving same instruction. Cash, we cannot disclose to even many people. So to avoid any difficulty for handling cash, always we will keep it as confidential. So we will, for example, in this email, I cannot disclose to any other person, like me, Husham, and Mr. Tariq Rahmatullah will involve during this stage. That is the confidentiality. There is nothing else.
So I think I might need to probe that a bit further. I mean, we looked at the company law earlier and the fact that a DIFC company's records need to be true and fair. They also need to be auditable by an external auditor. I mean, is your evidence really that you've been asked to keep it confidential and therefore, well, this just doesn't register anywhere? An auditor would not know anything about this $1 million in cash.
But it's not showing that type of confidentiality. This instruction need to be treated with high level of confidentiality means until finalize this transaction, we need to keep confidential. But of course, during the audit, we provide this all document to auditors. Nothing keep as confident. This all public document, like, I provide to auditors, I provide to Sudatel, our parent company. They recorded the transaction there in their book. So we never kept it as confidential. But during the cash transaction, arranging the cash, of course, we treat it as confidential.
Right. Moving on from this, what I'd have suggested to you is a slightly unusual feature of this being asked to be kept confidential. I mean, there are other elements of the transaction that are unusual. It is a very large amount of money to have in cash, isn't it?
You're asking to me, there is unusual transaction, right?
Is, well, let me put this in context. If you look at page 190, we can see what you said about this at the time.
Sorry, what is the question?
Go to page 190.
Page number 190.
Yes.
Okay.
So these are further emails about this. We can see that the subject of the emails, bottom of the page, just says, bottom of page 189 just says 1M, obviously means 1 million. We've deposited the check, so that's your confirmation of that. They've requested my passport, and then at the top of page 190, you're saying this is the easiest way and all other options will need more days, since it is a huge amount considering cash transaction. So given that your reflection at the time is that this is huge for a cash transaction, presumably it shouldn't be too controversial to accept that a striking feature of this transaction is a huge amount in cash.
Yes. Anyway, thanks to come to this point, this email. So here you can see when I did this transaction, immediately I informed to Mr. Sami Yusuf, he's the VP Finance of Sudatel, and I explained what I did for this transaction. So we can say the instruction came from Sudatel to Mr. Tariq Rahmatullah, then he instructed to me. Then the further communication with Sami Yusuf, I explained to him what I did as per the instruction. Then I was waiting for the further instruction.
Well, let's just dwell on that if we can for a moment, because whilst it may well be correct that you're looping some people into this, if we look at what the substance of this email chain actually is, so first of all, your email on the 30th of May, subject 1M, if we read that, there is nothing anywhere in this email chain which says this 1 million in cash for Sudatel, or this 1 million that we have withdrawn to be paid by reference to this invoice, or this 1 million which is going to be applied in this way. There's no reference to any use to which this money's put in this email chain, is there?
Yes, during this stage, even they're not from Sudatel, they're not inform us how they're going to use this money. So this is the instruction to arrange the money. Still, till this email, we are trying to arrange AED to dollar. So we need to arrange the dollar amount of $1 million. So even during this email also, you can see there is no other instruction how to pay, who to pay. This is only arranging the money.
Yes, but it's not arranging the money, is it? Because this email chain, none of these email chains on the 30th or 31st of May contain the word Sudatel, do they? It doesn't say forward Sudatel 1 million. You have no idea at this stage whether this is a Sudatel request, whether this is an EXPRESSO request, whether this is who knows what. The point is you have nothing in this email chain which tells us anything about what this money's for.
Yeah, during this stage, no.
And what we get is another unexplained email saying plans have changed. We need to delay receiving the money in cash. Keep the 1 million in a bank account. We need to access it in 24 hours time. You don't respond to that, do you, saying why?
See, that's what I'm saying. So here it's very clear. Mr. Sami Yusuf, VP Finance, he changed the plan. We need to delay receiving the money in cash. So it's very clear they're going to receive the money in cash. That's clear. And after that, the same email he CC'd to Mr. Tariq Rahmatullah. If you go up top of that page, 189, the same email he forwarded to Mr. Tariq Rahmatullah. So till now, during this email, there is no clue what to do. They're just going to receive the money in cash. That is the only clue we have. And
yeah.
As I said, yes.
So you're in the dark at this stage about what the money's for.
Sorry again.
Sorry, let me put it in less colloquial terms. At this point in time, you have no idea what this money is going to be used for.
Yes.
If we go, please, to page 76, back to your witness statement, just working through the chronology of all of this, because it's important.
Page 96.
Sorry, page 76, and I'm looking at paragraph 52. I don't need to take you to the documents. I think it's common ground. What happens with this 30th of May request is they can't hold on to the money for that. The transaction is reversed by Wall Street. And so you get to the middle of June and you have to make the request for the cash transfer again. And this is what you're dealing with at paragraph 52.
Yeah.
You say the above led to the cash transfer that took place on the 15th of June, which was converted. This transaction was recorded on Sudatel's intercompany statement of account, showing monies transferred from the defendant to Sudatel. It is equally worth noting that there are a number of other high-value transactions, for example.
Yeah.
Now, just pausing there, if one, and this circles back to the questions I was asking you earlier, if one looks at this list of transactions you've given, I think that the intention in your witness statement in citing these transactions at A through to G is to somewhat underplay the unusual nature of the transaction that you were being asked to effect. What you're saying is, well, look, here are a host of other fairly large transactions. But would you agree with me that with the exception of one of these, which is the one you refer to as A, all of these are bank transfers. So the convention in the accounts is PMT to this account is a transfer. If it's cash, it says cash. So most of these large volume transfers are made by bank transfer, by wire transfer, yes?
Not exactly. You know, there is Ghana disposal cash. This I received $1.5 million as cash, and I handled in cash to bank.
Yes, I think what I was saying to you is, aside from that one example at A, everything else is every other large transaction you cite here is actually a bank transfer.
Payment to TNC. Yes.
So the point really is that cash transactions, particularly of this size, even though they can happen, they're rare.
Not rare. You know, monthly wise, we have, if you go to the statement of account, we can see a lot of cash transactions.
A lot of cash transactions, but I'm talking about cash transactions of this size. The only other example in this financial year is what you've set out today. So in the course of a year, you maybe get one cash transaction like this, yes? Of this size, over $1 million.
The size, that's I cannot say now, but for me, cash transaction, we are following the same process for all. Even if it is 5,000, for 50,000 or 1 million, the process is same.
Well, that's not strictly true, is it? Because the size of the transfer, as we've already looked at when it comes to the company authorization matrix, can change the process, can't it?
Now there is, you know, if you are not going to book any liability, then that matrix is only the approval, like dispatchment of cash. For signing the check, that's okay. 1 million, up to 1 million, we need 2 signature. So sorry, more than 1 million, we need 2 signature. But creating liabilities is second stage. If it is belongs to EXPRESSO, we need further approval. If you are creating more than 500,000 euro, then we need EXCOM approval. Yeah. So in this case, there is no creation of liability.
So am I right, just to circle back to the question that I asked, is your evidence simply that you think a $1 million cash transaction is nothing out of the ordinary?
Sorry, what is the question? 1 million?
You think that sort of volume of transaction is perfectly normal? I've suggested to you that it's rare, You didn't accept that, so I'm asking you what your evidence is. Are you saying that it's commonplace to transfer volumes of money of that magnitude through cash transfers?
Yes, yes. If you go to instruction during the stage while we are arranging this cash, we don't know how we are going to use this money. So second stage, we are receiving the instruction with proper memo. They are going to utilize this money in this way. So for me, I'm not creating any liability in Dubai, but I'm just transferring this transaction to Sudatel because the liability creation is happening in Sudatel. That's their own money. They're creating the liability. They're recording the expenses in Sudatel, not in EXPRESSO. So during this transaction, I arrange the money. I facilitate this money transfer to Sudatel people. Then they create the liability in their level, Sudatel level.
Well, again, I'm not quite sure I follow you there, because what you say in your witness statement and what you're saying here is you are recording this transaction, this transfer. And so would you accept the premise that if you have a company here, EXPRESSO, and it is holding funds, which are its property, and they send it to another company, whether it's a third-party company or an inter-group transfer, what is still happening is you are taking money that belongs to one entity and depositing it with another. So that is a transaction which you have, seemingly on your evidence, recorded in the accounts, yes?
There is difference. If it is third-party company, of course, we need to get proper invoice, proper approval, proper, if you are going to create the liability in our level. But if I'm arranging some cash for my parent company, I don't want any approval for that. I just want to get instruction how to act.
Yes, but it doesn't mean that you're not creating a liability, does it? You're transferring money that was on day one EXPRESSO's money, and on your analysis on day two becomes Sudatel's money. That is a creation of a liability, isn't it?
So you're asking creation of liability. If it is Sudatel money, then I'm not getting the question actually.
Well, it's EXPRESSO's money at the start. You say it's Sudatel's money at the end. In order to make that happen, EXPRESSO have created a liability and transferred that sum from its accounts to Sudatel's accounts, correct? They're different entities.
Now for this transaction, this is Sudatel money, even this is not EXPRESSO money. As maybe in my witness statement, I clearly mentioned EXPRESSO having no operation in UAE. So we have no revenue, we have no budget for this type of transaction. So this all money belongs to Sudatel. They are controlling the cash flow of this particular these amounts. So they can instruct, they can receive the cash in their custody. Then they can utilize. Once they utilize the money, then they will create the liability or expenses, whatever in their books in Sudatel. For us, we are just arranging the money. Then we send the document to Sudatel to record the transaction in Sudatel level.
It may well be that that is the practical effect of some intercompany agreement, but the reality here is that you have created an accounting entry which explains why EXPRESSO have sent this money that it held to someone else. And so in creating an accounting entry, you must have been treating this as if it's EXPRESSO's money. Otherwise, you wouldn't have done anything, would you? If this is just Sudatel's money, this has nothing to do with you at all.
So this is Sudatel. My point is that since it's Sudatel money and they requested in dollar, we arrange the cash in dollar, and the creation of liability in their for me in EXPRESSO, I just want to show the transaction. We withdraw the money from bank, so we have to effect only in two accounts, one in bank and the other one in related party accounts. So that is the only one transaction I have to post in my book. I clearly post that transaction. Accordingly, Sudatel will record the same transaction in their book in Sudatel level. So they will create either liability or expense, then they will credit Expresso accounts. That is the process of reconciliation.
I think we're at risk of running around in circles here. Let me put some relatively straightforward questions on this. At the beginning of this process, the account that this dirham amount is in, which you use to procure a cash amount, that is the Expresso bank account, isn't it? It's the one that you're an authorized signatory for.
Yes, that was an Expresso bank account.
Yeah. And to withdraw the amount from the Expresso account, you needed Mr. Rahamtala's signature and you needed your signature to authorize that.
Yes.
Okay. Looking at the intercompany reconciliation again, if we can. So first of all, let's look at the examples that you've set out in paragraphs 52A through to G of your witness statement.
Page number?
It's the page we were on before, so it's 76 and 77.
77. Yes.
So I appreciate that the narratives that accompany these are short, but would you agree with me that we can at least superficially see from the descriptions what these payments relate to? So, for example, A, Ghana disposable cash, STG, Nilin Bank. B, we've got payments to Tian's Huawei. C, we've got ADIB Ijara payment. D, we've got payment to ZTE CBD for Sudatel 18th and so on. So the point is that it's short, but you can skim these account entries and broadly ascertain what these transactions are, correct?
These all are the high value transaction. I just took some points to explain there are high value of transaction. And the first one is purely cash transaction. We receive in cash and we deposit in cash.
Yeah, sorry, that's not my question. What I'm saying is when you read these, even though they're short entries, you can get some understanding of what the transaction is. So the first one at A, it's Ghana disposal cash, and it refers to the bank it's going to. B tells us that it's a payment that's being made to Huawei. C tells us that it's a payment in respect of an ADIB Ijara. So even though there are payments sometimes made on behalf of Sudatel, we can see roughly what they are. There might be supporting documents which give us more detail, but there's some detail there. Would you agree?
Yes, I agree.
And if we go to page 140, 140.
140. Yes.
If you look in the middle of the page, there's a green highlighted. There are two green highlights. One is in the middle of the page. And if you look at the entry below that, we have this transaction, 15th of June 2016 is the date, for just over $1 million, and we've got the dirham amount just to the left of that. So that's this 2016 transaction, isn't it?
2016 transaction, yes.
Yeah, and all this says is cash for STG. There's no other context here, is there?
Yes.
That stands out like a sore thumb, doesn't it? Because if you look at all of the other payments surrounding this, they all have a format and a description which give us at least some context, don't they? So if we look immediately above it, payment on target, EMR, due diligence expenses, below it, payment to Mobad, STG, date, payment to ITP publishing, and so on. This is the only one that is completely devoid of context, isn't it?
If you go to the same page, second last transaction, you can see cash to STG from Chinguitel, 250,000. So this is the nature, like, we are just transferring the money or arranging the money for parent company. In this stage, we don't know how Sudatel is going to utilize this money. So the same page which you are showing, The second last transaction is similar.
So I'm just going to write that down. So your evidence is that at this stage, we don't know how Sudafed is going to use that money.
Yes.
Yes?
Yes, yes.
Let's look at the entry from another perspective. We know it's inaccurate even on your own evidence. And we know that if we look at paragraph 45 of your witness statement. That's at page 73.
Paragraph
45.
Okay.
So in paragraph 44, you've explained how you procured the cash amount. At 45, you say, we then received a verbal instruction from Sami Youssef to arrange the fund. We deposited another check in favour of Wall Street Exchange. We collected the amount after a few days. Hussein Suleiman and I together went to Wall Street Exchange to collect the amount. When we collected it, we received an instruction from Sami Youssef to keep the amount in safe custody until further instruction. After consulting with Mr. Rahmatullah, Mr. Suleiman, I purchased a safe to keep the money in, etc. You kept it there for another 2 weeks, you say. So based on even what you say there is no transaction between EXPRESSO and Sudafed on the 15th of June, is there?
On 15th of June?
Yeah.
Yes. This
the only transaction on the 15th of June is EXPRESSO and Wall Street Exchange when you convert a dirham amount into a dollar amount.
No, it's happening like, once we did the transaction, for me, as I said, this transaction will affect two accounts, one in the bank and the second double entry. The second entry will go to Sudatel accounts, means the intercompany accounts. So when I am receiving this cash, I know this cash for STG. So I will put the description as cash for STG. The same day it's happening. When I arrange the cash from bank, I have to enter the transaction.
But there isn't an intercompany transaction on that day, is there? The only transaction on the 15th of June is EXPRESSO handing over just over 3 million dirhams to Wall Street Exchange, and Wall Street Exchange giving EXPRESSO $1 million, which it then goes and puts into a safe. So my question is, do you agree with me that the accounting entry that you have caused to be created on the 15th of June is wrong? It's false. It's not an accurate account.
Just a minute. I think, Mr. Doherty, that's a two-part question. And the question required Mr. Moorkant to accept the first part of your question, and I don't know that he has accepted it.
Sorry, Your Honour, which I'm happy to...
You put to him that there was no transaction on the 15th, no transaction effectively between on the 15th it was still EXPRESSO's money, and the only transaction was between EXPRESSO and Wall Street. Now, I understood from Mr. Moorkant's previous answer that he didn't accept that, and yet that's the premise on which you went on to put to him that it must be false.
Right, let's work through what the statement says. So you arrange the deposit of the check with Wall Street Exchange on the 15th, yes?
Yes.
You say that you go to collect the money a couple of days later. I'll come to inspection. I think there's documents suggesting this was the 21st of June. It well be that you don't recall, but when we say a couple of days later, is that there or thereabouts?
Yeah, as I said, there are further instructions. Initially, there was one instruction to arrange cash, so we act accordingly. Then the further instruction is coming like, first we got to keep the money, to delay the transaction, to delay the receiving money. Then after, it took another 15 days to collect the money. So for me, the initial transaction is very important. When I receive the money or when I release the money from my bank account, I have to record that transaction. That I did. Like, I cannot record into Wall Street Exchange as a party. Instead of that, I know this money is going to Sudatel. So I record the transaction, one side bank and the second side cash to STG for intercompany transaction.
Yeah, let's take through the chronology. Okay, 15th of June, Wall Street Exchange are asked to give you the cash amount. Yes.
They're supposed to give, yes.
Yeah. At that point in time, and we've already looked at what the underlying documents look like, the only request that has been documented that you're acting on was Mr. Raham Tala's email saying, withdraw the money, keep it confidential. And the second set of requests, which said the money, we can't take receipt of the money now, we need to delay. Neither of those had said anything about Sudatel, did they?
That was the second instruction, to delay receiving this money from Wall Street Exchange.
Yeah. So my point is that the only instruction, as at the 15th of June, is the instruction to withdraw the cash amount from Wall Street Exchange. So EXPRESSO, get the cash. Yes?
Yes.
So when we see an accounting entry, also for the 15th of June, saying cash to Sudatel, that can't be accurate, can it? Because the chronology after the 15th of June is you hold on to the cash for 2 weeks before it's handed over to anybody.
Yes, of course, if that is the only information which I have, the instruction came from Sudatel, and we act accordingly to arrange the cash. So we know the money is going to Sudatel or on behalf of Sudatel. In both cases, this is the correct entry.
Well, it's still not correct. So let's assume that you're right. Let's assume that even though it's not documented, you still had in your mind at that time that that amount of money would eventually go to Sudatel. The reality is that the accounting entry that you caused to be created is still false, isn't it? Because the money does not go to Sudatel on the 15th of June. It goes 2 weeks later.
Yes, but for bank transaction, we need to effect the transaction as per the bank statement. For example, if I made a transaction in bank today for bank reconciliation purpose, we have the transaction the same day. Whenever the cash released from our bank account, I have to effect the transaction on same day.
But all that's happened on the 15th, let me just put this really clear, all that has happened on the 15th is you've taken money in dirhams that belongs to EXPRESSO, you have transferred it into dollars, and so those are just dollar amounts owned by EXPRESSO, correct?
No, actually, the chronology is different. Actually, the instruction came 30th of May. Then I released one check very next day, and when I received the delay instruction, the instruction from Mr. Sami Yusuf to delay the cash withdrawal, what happened? Wall Street Exchange, they released back the money to our account. Then after a few days, we got another instruction to do the same transaction. Then this is the second check which I issue for the $1 million. So this is not like, this is not happened in a day. There is 15 days gap to actually get the money in hand.
The money in Sudatel's hands, yes?
Yes.
And I think the words you used there were Wall Street transferred the balance back to our account. And what you mean by that is EXPRESSO's account.
EXPRESSO account, yes.
Yeah. And that's why you need to go out and buy a safe.
No. First time they transfer back the amount to our account.
Right. So let's move forward. 15th of June, you draw the check. You say in your evidence, a couple of days later, you go to collect the money. You then say you put it in a safe. It stays there for 2 weeks. And it's after that 2-week period that we have this handover, which I'm going to come to. So given that that is your own evidence, I just want to look at what appears to be a bit of a confusing extract in your witness evidence that seems to contradict it a little. So if you look at paragraph 46, page 74, you say that before collecting the amount, Sami Youssef sent me the approval memo, I believe on WhatsApp, for $1 million.
Yes.
And this approval memo, you go on to describe what it says at paragraph 47.
Yes.
And in paragraph 47, you say this relates to the handover meeting after the money's been in the safe for 2 weeks. I handed over the $1 million to Tariq Zain, who's the former group executive president. This was done in the presence of Sami Youssef, who was the former vice president of finance in the EXPRESSO Telecom Group's Dubai office. This was a third person with them, and Tariq Zain asked him to carry the bag while they were leaving the defendant's office. I received a receipt from Tariq Zain, which was the approval memo for the utilization of the money in Mauritania. That memo explained the utilization of the money. I exhibited at FM 29. Yes?
Yes.
So that appears to be contradictory, doesn't it? Because on the one hand, you're saying you received the approval memo before you collected cash, but you're also saying you received the approval memo after handover. So they can't both be right.
Where I mentioned after handover?
You say that in paragraph 47. I received a receipt from Tariq Zain, which was the approval memo for the utilization of the money in Mauritania. That memo explained the utilization of the money I exhibited at this day.
Yeah. So,
and what I'd suggest to you that, so I suggest to you that it must be paragraph, on your evidence, it must be paragraph 47 that's correct, because I'd suggest to you that it wasn't possible for you to have received the memo before you collected the money. And perhaps if we go to the document itself, that might help clarify why that is. So if we go to page 316, this is the memo itself. This is what you've described as the approval memo.
Yeah, for me, as I said before, the utilization of money is not EXPRESSO's concern. For us, we arrange the money and we hand over the money to Sudatel people. And this memo is just a supporting document. When I receive this supporting document, while I am sending this transaction to Sudatel for reconciliation, I have to send the document. If I'm not receive any approval, then this is their duty, how they utilize their duty to get the approval in Sudatel level for the liability creation or the expenses. So for us, once we hand over the money, the transaction is very clear. This is cash to STG. Then from Sudatel level, they will record the actual liability or expenses, not in EXPRESSO level.
Have you got that document in front of you?
Yeah, I received. Yeah. During this stage, like during the handover stage, I know how they're going to utilize this money as per that memo. But finally, while entering in Sudatel, they have to make sure this is as per the memo they utilize the amount. That is not EXPRESSO duty, but Sudatel.
Right. Well, let me explore that with you, because if you look at this document, at the top of the page, we have the date, which is the 30th of June, 2016. Yes?
For the document memo?
Yes, the date of the document it's in the table on the left-hand side says 30th 6th 2016. So 30th of June 2016, correct?
Okay.
So presumably you're bound to accept that when you first asked Wall Street Exchange for the money on the 30th of May, and then you subsequently asked Wall Street Exchange for the money on the 15th of June. And when you went a couple of days later to pick up the money from Wall Street Exchange, you couldn't have seen this memo because it didn't exist. It postdates all of those things.
No, they're not convey this message, or they're not send this memo during that stage.
Yeah, so you didn't have it then. Is that what you're saying?
Yes, yes.
Yeah. So just to skip back to, I'll not take you there, but I'll read it to you. Whenever you say at paragraph 46, I remember before collecting the amount, Sami Youssef sent me the approval memo. That can't be right. Because it postdates that event.
Yes, yes. He sent me my, I cannot remember the date, but I remember he sent the approval memo. Yeah,
well, this must have been after this date, but in any event, we don't have any WhatsApp message. We don't have any evidence on the record about that, do we? So if we then look at what you say at paragraph 47, what you're saying is, I received a receipt from Tariq Zain, which was the approval memo for the utilization of the money in Mauritania. That memo explained the utilization of the money. So the context in which you are receiving this document, you say, is on the same occasion when you've handed the money over. So you've got the $1 million in cash in a bag, presumably. It's handed over, and you describe this as being your receipt, yes?
For paragraph 47, I mentioned I handed over 1 million to Tariq Zain. And so what was the question regarding this?
So you say in your evidence, we hand over the money. I then receive a receipt from Tariq Zain, which is the approval memo. And that memo explains the utilization of the money in Mauritania. So the point in time on your evidence that you're receiving this document at 316 is this is being handed to you when you've handed over the cash.
Even before receiving this money, I received the memo from Mr. Sami Youssef.
Well, that's not what you say in your witness statement. I mean, perhaps if I can take you to another source for this to see if that helps refresh your memory. If you can go, please, to page 252.
Page number?
252.
252.
Yes.
Okay.
So bear with me, I'm just trying to identify in the page where I can take you to this.
Page number 252.
Yeah, sorry, 253.
Yes.
12 lines down. This is your interview.
Okay.
At the time you were suspended. And we've got a question from Abdeen. This question, there are no proper documentation for such a large amount of money. Do you think this is a proper procedure? And then you give evidence which seems to correspond to what you say in paragraph 47 of your witness statement. I was in the office when Tariq Zain and Sami Youssef gave the money to a third person who was in the office and with him at that time. And they gave me the receipt after they gave him the money.
Yeah. So this is
so
like,
the receipt here is the memo. That's what you've said in paragraph 47.
Yes, money to the third person who was in the office with them at the time. They gave me the receipt after they gave him the money. So this is the receipt when they hand over the money to third person, not me. I have not received any receipt from the third person. You know, this third person is not I'm not aware about that person. I'm handing over this money to Mr. Tariq Zain.
And you say in the interview that Mr. Zain hands the money to the other individual, and you're then given the approval memo as your receipt, yes?
Approval memo, yes.
Yeah. So again, just to break this down into stages, you have twice gone to Wall Street Exchange, once on the 30th and once on the 30th of May, once on the 15th of June, and you've asked for EXPRESSO to draw $1 million in cash. At that point in time, your evidence given earlier was that you didn't know how Sudatel was going to use that money at the time, correct?
Yes.
And based on the documentary evidence we've looked at, there are certainly no documents that even tell us at those dates that the money is going to go to Sudatel and isn't going to be used by EXPRESSO for something else.
So what is the question regarding?
Well, prior to this memo of the 30th of June, there is no other document which explains any use, whether by Sudatel or EXPRESSO or anybody else, for this $1 million. We just don't have any evidence at all.
No, till I receive that memo, of course, you know, we know as per verbal instruction, we know they're going to utilize this money somewhere, but for us, we are not received any proper memo. But before receiving the money, I remember they sent the memo by WhatsApp. That time we know how they're going to utilize, but it's not going to affect in our books. There is no changes coming to our transaction. While I'm receiving this money from Wall Street Exchange, the same transaction I can continue. There is no change to that transaction.
What I will suggest to you, based on the questions I've asked you so far and how this money ends up being handed over and ultimately a third party leaves the room holding this bag of cash, the first time that you're provided with any document on your own evidence telling you what this money is actually going to be used for is only handed to you after you've already passed the money on to someone else.
The first instruction to arrange the money and hand it to Mr. Husham is internal transaction only. Not third party. You're mentioning third party, that is wrong. First instruction, there is no third party.
That's not what happens here. This is, either way you look at it, let's look at it one of two ways. Either you've gone to this meeting, you've handed it to Sudatel, members of Sudatel, so you say Tariq Zain and Sami Youssef, and then what you say you witness is Tariq Zain then taking the same money, giving it to this third person who leaves the room with it. On your analysis, either that money is going to Sudatel or it's being paid by EXPRESSO to a third party on Sudatel's behalf. But the question I have for you is that the only document that you've been given explaining anything about the nature of this transaction has only been handed to you after the cash is already gone.
No, for me, there is no two scenario. It's only one scenario for me. I'm arranging this cash for Sudatel. For example, if I got instruction to pay a third party, of course, then I will ask for all the details, and I will get same like the previous transaction which you explained for open mind. I personally contact the third party. I get the bank details. I transfer the money to them. I hand over the document to them. So that is the process. If I got instruction to release a particular party on behalf of Sudatel, but this transaction is different. This transaction, we are just arranging money for Sudatel. Then Sudatel is utilizing the money, not EXPRESSO.
But let's be as generous as possible and say it's correct that this was money that was intended to go from EXPRESSO to Sudatel. It's still correct, isn't it? The first time you've been given a memo explaining, you say, the purpose of the transaction and documenting the purpose of the transaction is still after you've given the money away.
Sorry, again, when I received the memo?
Yeah, you receive the memo after you've handed over the cash. So the first time you have any documented explanation of what the money is for is after you've already given away the cash.
Yeah, even we don't know who is going to collect. You know how it's happening. As I said before, first we will get instruction to arrange cash. Then we will wait for further instruction. Maybe even I don't know, Mr. Tariq Zain will come and collect. Maybe they will instruct to pay on behalf of Sudatel. They will give further details. So during that stage, we don't know how they're going to utilize, what type of instruction we are going to receive. So in this particular transaction, what happened, Mr. Tariq Zain and Mr. Sami, they came directly to office and they collect money. For me, this is very clear transaction. You're the person who is authorized and who is the authorized people, they collect the money.
Right, I'm not sure it's an answer to my question, but I'm not sure I'm going to get one. Let's look at the content of the memo if we can. So go back, please, to page 316.
Page number
316, 316.
316. Okay.
Now you give a bit of an explanation about the different colored text that we see here.
Yeah.
So the bit that's in blue, what you say at paragraph 49 of your statement is that these are handwritten notes added to the memo by Mr. Sami Youssef, and it was sent to you, I think, a couple of weeks later in July 2016. Just your honour, for your note, that's paragraph 49 of the third witness statement. If we look at the content,
is that right? Let me just look at that again.
That's my understanding, certainly. So if one goes to
what
paragraph
I'm reading,
49.
Yes, what I'm reading, Mr. Doherty, is that note 1 and note 2 were added, but
yes.
Paragraph 48 is something different about the words it is deducted from.
Well, Your Honour, I think in fairness, one has to look at the Arabic text to really try and understand how it came about. So if you look at 317, and I'm sorry to cut through Mr. Doherty's cross-examination. I hope he doesn't take any disrespect to me intervening. But I would suggest if one looks at that document, then one can see, you can make out a number 1, even though it's Arabic. It's got, I can assure you, it's got the same numerical image. And number 2 is the second circle. And then there is some text that's diagonal, it's adjacent.
Yes.
So I hope
if it helps, Your Honour, I'm asking the question based on the premise that what Mr. MOORKATH says in his statement is correct, and I'm only asking about bullet points 1 and 2. So this is the text that is set to be added on the 20th of July.
I misunderstood, and I wanted to make sure Mr. MOORKATH didn't misunderstand. I thought you were referring to all of the text in blue, which includes not only note 1 and 2, but the sentence after it.
I see that now. Yes, I agree with that. Well, I'm going to ask you, Mr. MOORKATH, about bullet points 1 and 2, yes, which you said, paragraph 49, 2 more notes were added on the 20th of July 2016. So if we look at those notes, which are some weeks later, what they say is, 1, the CEO indicated that he would submit a receipt for the amount from the presidency of the Republic. So pausing there, what I would suggest to you that note means is that some 3 weeks later, after the cash is handed over, the position is still that there's no signature to say that anyone from the Mauritanian Republic, rather, has actually received the money. That's still outstanding, yes?
Yeah, yes, this is the point actually. You know, if you go to the same memo, this came from Mr. Tariq Zain to Mr. Sami Youssef. So this is the internal memo in Sudatel level. So basically they got approval to release the money through EXPRESSO, and Mr. CEO Tariq Zain, he indicated he would submit a receipt for the amount from the Presidency of the Republic. And Mr. Sami Yusuf, VP Finance, he mentioned for the disbursement of this amount, the registration of the amount is suspended. The registration of the amount is suspended until it is approved by the administration of Executive Committee. So this is very clear, the money they have received, and they were waiting for the receipt from Presidency of the Republic.
Yeah.
So this
there's no receipts at that time, I think, is the question.
That is the complete transaction completely related to Sudatel, not EXPRESSO.
Right, that's your evidence. This is Sudatel's problem. So we've looked at the OpenReach transactions earlier, where you had an email from the CEO saying approved. So this was for a much smaller invoice, of course. But if you look then at bullet point 2, it says the disbursement of this amount, the registration of the amounts is suspended until it is approved by the administration or executive committee to disperse and classify the amount. So what that note added a couple of weeks later suggests is that the disbursements hasn't even been formally authorized by Sudatel 3 weeks after the money's been handed over.
Yes, yeah, it's very clear for me now. Like, when I made this transaction, I forwarded this transaction to Sudatel, and they have this memo in their custody. They can delay the registration for maybe 1 month, 2 months, even until the finalization of audit. But during the finalization of audit, they must enter, or the intercompany reconciliation will show this difference. Or if they need any additional document, supporting document, immediately when they receive this transaction, they will ask to me, because I'm releasing an amount to Sudatel, and if they are not received, or if they have no approval to receive that money, immediately they will ask question to me. So for this transaction, they know how they're going to utilize, and they were just waiting for the Presidency of the Republic receipt from the Presidency of Republic. So for Sudatel level, they know how they're going to utilize. For us, even if it is not received, this receipt, it's not going to affect EXPRESSO. I can post the entry in our level, but Sudatel, maybe they have to wait until they receive this receipt.
Based on the documents that we've already gone through, I would suggest to you that at the point in time this money is physically handed over and a third party walks out of the room with it, you had no idea what this money was for.
While handing over, I know, I received this memo before handing over, so I know how they're going to utilize. Even though it's not my concern, but I know how they're going to utilize.
Well, I think I have to put it to you again, because I suggest you didn't receive the memo before. Your own evidence is that you received the memo after the money had already gone.
No.
That's what you said in paragraph 47, and it's what you said during your interview.
You know what happening? First, I received the memo without any note. It's like when the memo is ready, Mr. Sami Yusuf is sent to me. That time there was no note. This note is coming after they receive the money. Maybe they hand over the money to the Presidency of Republic. So this note came after the handing over, maybe.
Yes, Mr. MOORKATH, but that's not the issue. Ignore the note. You didn't have the memo in hand. You couldn't have read the memo until after the money was already gone. That's the point, isn't it?
No, I clearly mentioned in another paragraph, I received the memo even before handing over the money.
Well, in fact, you say you received the memo before you collected the money, but I'll put to you, and I'll put to you again, that can't be right, can it? Because this memo actually post-dates those events.
Sorry, as I said, I received the first memo before handing over the money. I remember during the handing over, I'm not sure, but during this conversation, I can recall he given the same memo. maybe with Mr. Tariq Zain note.
Mr. Moorkhath, what Mr. Doherty is putting to you is this: do you have the memo, page 316 in front of you?
Yes.
Mr. Moorkhath said that it post-dated the what you say in paragraph 46. So what he is saying to you is that in paragraph 46 of your statement, you say, I remember before collecting the money, Sami Yusuf sent me the approval memo. I believe it was on WhatsApp for USD 1 million. What Mr. Doherty is saying to you is, if you look at that memo, at the top left-hand side, in the fourth box, it says page 1 of 36, 2016. So Mr. Doherty is saying to you, he says the memo has the date 30 June 2016. From that, he is putting to you, you couldn't have received it before the 30th of June 2016.
Your Honor, that is correct. Actually, the money handed over not in June. The money has been handed over in July. That's point I mentioned in my witness statement also. The money has been received some first week or second week of July.
I see. I'm sorry, Mr. Doherty, I wanted to clear it up for my benefit.
That's quite all right. Now, let's see if we can find some common ground about this relative to Expresso's internal payment process that we've looked at. Do you accept that for this transaction, before you withdraw and collect this cash, you don't anywhere have an email chain from Sudatel showing that there was approval of a particular payment that was due to be made on their behalf, or for that matter, even just requesting the transfer of funds?
Yeah, for me, if I got an instruction from my CEO to arrange money, since it's common in our company to arrange money for Sudatel or for some other purpose, so nothing unusual. So during that stage, it's not unusual. I can arrange the money, then I can wait for further instruction.
Well, I'll come back to Expresso's internal process in a moment, but your evidence earlier is that when you got a payment that relates to Sudatel, that you needed to receive some kind of internal approval from Sudatel. And I think my question is relatively straightforward, is whether you agree that there's no document, no email here prior to you obtaining this $1 million in cash from Sudatel saying, we approve you going to get this foreign currency.
Yes. So I said earlier, each transaction have different process. If you are saying this is the process and procedure of company, then we can say I break the policy or I break the process. But for Sudatel, each transaction have different process. For example, now, if this transaction is happening now, this will happen. Even after, we are discussing the policy matter, but there is no other way but to follow the same process or different process as per the circumstances.
Okay. So I think your answer is that didn't happen in this occasion. Would you accept that in this transaction, you don't have a copy anywhere of some invoice or some underlying transactional document from Sudatel telling Expresso what this money is paying for? Agree?
No, there is no invoice, but this memo.
Yeah, you don't have any underlying document issuing a payment request from the Republic of Mauritania saying transfer these funds, correct?
I have even no instruction to pay Mauritania.
Yeah, and you don't presumably on that basis have a signed formal receipt of funds from anyone from the Republic of Mauritania when they're handed over?
I said I'm not handed over to Mauritania. I hand over to Mr. Tariq Zain only.
Yeah. Now, we looked at the OpenReach transaction earlier, which was an example you said of payment being affected for Sudatel. Could I ask you to turn up page 175, which is one of the documents I was looking for, but my internal page references were incorrect. Do you have that document?
Sorry, which page number?
175.
175. Yes.
So you see, this is another one of those money transfer instruction forms. Do you see under reference, it says open mind invoice?
Yes. Open mind.
Yeah. So payment being made for Sudatel, and then at the bottom left of this page, whose signature is that?
Yeah. This is my signature and Tariq Rahmatullah's signature.
Yeah. And the EXPRESSO company stamp.
Yes.
Yeah. So for this transaction involving Sudatel, do you agree with me that there is no money transfer instruction or some formal document showing an A and a B signature for the disbursement?
I can say this is different transaction. This is on behalf of Sudatel. We are paying to third party. The instruction is different actually. So this is very clear. We know we can identify who is the beneficiary, and accordingly we can act. So we are facilitating this transaction on behalf of Sudatel. They provide the details and they given the instruction. Accordingly, we acted. The other transaction in question, that is entirely different actually. You cannot say this is both transactions are same.
If you go over to page 176, and again, this is just to complete the record, do you see that this is another of these domestic wire transfer confirmations? And if you look send wire to nickname, it says open mind. So this would have been, you know, effectively the formal receipt or the proof that the payment has been made. Would you accept there's no equivalent documentation that has been formally kept in relation to this $1 million transaction?
We have the same. For 2016, we have the check copy. You know why this domestic wire transfer print is coming? If it is bank transaction, bank transfer, then we will get this type of document. If it is check payment, we have the check. That is the proof. We can see both signature on the check.
And just coming back to the EXPRESSO internal procedure, you have said, well, I was told by my CEO to do this, to bring about this $1 million transaction. Given the volume of funds that are being dispersed in that way, would you agree that there is no authorization from EXPRESSO's own executive committee in relation to this transfer?
Yeah, I believe I explained the same point. When I receive this instruction, I'm not required any further approval to release the money and arrange the money. The process is we are arranging the money in our custody. It's not going to any third party. For example, we have bank account, we have petty cash. So we are just transferring this money from bank to our cash. So there is no third party involved during that stage. So that instruction is enough for me. Since he is my direct manager, I'm getting instruction from Mr. Tariq Rahmatullah. So that is enough for me.
So your evidence is the instruction is enough. That's as far as you need to go from EXPRESSO's point of view.
Yes. For the EXPRESSO point of view, that is an internal transaction. We are just arranging the money.
Okay. Let's just move past the transaction now. Can we go to page 196?
Yes.
So if you look at the bottom of this page here, email from Shireen Abdul Rahman on the 24th of July. This refers to the intercompany entry that you've created. We've already looked at that entry and you know what I have to say about that. But she says, please send documents of below transactions. So presumably her expectation when she sent this email is that for a transaction like this, you would have had some kind of document explaining it.
That email is very clear. Like, I'm sending this email to Sadishu. Could you please check it with VP Finance?
Mr. Moorkathe, would you just stop a minute?
Yes, please.
Stoli, was the question what Mr. Moorkathe thought or what Ms. Shireen thought? I'm not sure.
Yeah, it probably wasn't entirely clear. What I suppose I would be asking is, presumably one's understanding of an email like this would be that the person requesting that you send documents expects you to have documents.
Yes. So as I said before, when I am sending this transaction to Sudan, maybe they were waiting for the further instruction or for the receipt from Presidency of Government. That's why Shireen is asking to me to send the document. Then I am informing the manager of Shireen, dear Mr. Sadishu, to get the transaction detail or supporting document from VP Finance.
Yeah, so you have basically deferred this question on to someone else. You said go to them, they'll answer your question seeking documents, yes?
No, I'm just asking to check the details with Mr. Sami Yusuf.
From a process perspective, where we've got someone who's in the Sudatel accounting function coming to you based on a transaction that says cash for STG, does that not mean that the normal process would be, even if it is this intergroup transfer, you should still have documents?
Yes. I provide the document already.
At this time, we suggest to you that you actually don't have any of the underlying documents because no one's told you what this transaction is about.
Mr. Daruti, this email, you can see the date of that email, 24th of July. So Shireen Abdurrahman still waiting for the final receipt to register that entry in their level. So for me, I have no other document. This is Sudatel. So what I did, I sent the same email to Mr. Sadishu. He's a Sudatel employee, Sudatel finance person, to check it with VP Finance. So after this, you can see they manage the transaction in Sudatel level. After that, no other communication. So it means they receive proper document to register the transaction in Sudatel level. If they're not received, the email communication will continue until they receive the proper document.
I'm going to move on from the 2016 transaction. Just one final question on it at page 78 of your witness statement, paragraph 56. You refer to the process of auditing. And one of the things that you say is that there's an annual external audit that takes a balance confirmation from Sudatel and the defendant and other related parties, and auditors independently set the balance confirmation request to the other party. You then exhibit a document showing that the overall transacting, which is over $1 billion, matches with the accounts. And the consequence of that is you say, well, it means that Sudatel recorded the transaction in their books. And if they hadn't, it would have shown up as a difference. And I think that that's your justification for saying, well, this was a proper transaction, otherwise they wouldn't have put it in their books. We've touched on this already, but your evidence, and as part of your responsibilities that you said on your witness statement, was that Sudatel's accounts are reliant on the information you provide, correct?
Yes, during the audit, as I mentioned, we need to get balance confirmation from both company. not only from Sudatel, but also from EXPRESSO. So both companies should confirm the balance to their own auditors, means their auditors. So
Yeah.
EXPRESSO should confirm the balance to Sudatel auditor. Sudatel should confirm the balance to EXPRESSO auditor.
Given the way this works, if you provide incorrect information to Sudatel, Sudatel's accounts are also going to contain incorrect information, aren't they?
Sorry if I give the incorrect information.
Yeah, if you've given Sudatel the wrong information about a transaction in the first place, the fact that its accounts end up being wrong just proves that you give them the wrong information in the first place. Doesn't do much more than that, does it?
First of all, I cannot give a wrong information for this type of transaction. For me, I given this money to a person in Sudatel. If that person deny I am not received, then you said that is correct. We can say a wrong information. But Sudatel CEO, the president of Sudatel, Mr. Tariq Zain, he himself confirmed, I received this money, we hand over the money to presidency, we are waiting for the receipt. Then there is no question of wrong transaction.
All right. If you've still got your witness statement open, could you scroll down to paragraph 64? It's on page 81.
Mr. Doherty, we've reached 4 p.m. Dubai time, which was the scheduled time for today. How much longer do you think you might be? I'll let you continue.
What I might suggest, Your Honour, is that we deal with the questions around the 2017 transaction, because ultimately I think those are issues that you're going to have to get into with all of the witnesses. Some of the questions I have after that are what I suppose you might describe as more about the process that followed, and some questions around contractual entitlements and so on. Assuming no one's going to make a point of me not putting contractual terms to the witnesses and so on, I think there's probably scope for trimming out some of the benefits related questions, in which case, if we were to adjourn, I could probably finish pretty quickly in the morning if that's the most efficient course, and leave all that over for submission. I think it probably is more of a submission point.
I would prefer continue this evening if we can do it reasonably. Mr. Moorkath, are you able to continue for a while?
Yes, I can continue.
Mr. Costel, now I know you're not at the top of health. Are you all right to continue?
I am, if Your Honour would actually just give me 5 minutes.
I will, but I'll first of all just check with the court officer. Ms. Norton, if we continue on, will the recording continue, and are we all right to continue on for a while?
Yes, Justice Lemiere, that's absolutely fine.
All right, well, thank you. Well, we will take a 5-minute break and then we'll continue.
Thank you, Your Honour. Just for clarification from Mr. Moorkath, obviously I can't speak to him during the currency of his evidence.
Okay.
All right, thank you.
Thank you. Thank you.
If everybody is by your screen. Yes, I see. All right. All right, well, we're ready to continue.
Thank you, Your Honour. As I said, Mr. Moorkath, we were going to move on to the 2017 transaction. I suggest if you're still at your witness statement, you could have a look at paragraph 64. That's at the bottom of page 81. And the way you open on this is you say, or you suggest that there is some sort of instruction was received from Sudatel, but I was unable to gather the documentation and information pertaining to the 2017 transaction. And in paragraph 66, you go on to say that you thought the 2017 transaction was a normal transaction, you followed the normal procedure, there was no abnormality, and you believe that you forwarded the related supporting documents to Sudatel, but you were unable to retrieve those. just having a look at the state of the documents, if we can, because really that is one of the core issues with the 2017 transaction. If you go to page 237, first of all.
Page number 237.
Yes.
Yes.
So here at the bottom of the page, we've got an email on the 20th of July 2017. The subject, Sudatel statement of account till June 2017. This is to Sadisu at Sudatel. You say, please, dear Sadisu, please find attached statement till June 2017. Please note below 2 transactions, and you can update to Shireen. And then you refer to 3rd of May 17 transaction, fund transfer for STG. So that's the $1 million 2017 transaction. And if we go over the page to 238, it says first transaction for USD. I've already reported to Shireen in May 2017, but she was asking for a supporting document. And then we got the response and says, okay, Faisal, thanks. So what this email appears to suggest is that as of the 20th of July 2017, Sudatel's position seems to be that it hasn't got the supporting documents for that transaction.
Yeah, this is same like 2016 transaction. In first instance, maybe they have some approval, but they are waiting for additional document. So in my email, I was checking with Mr. Sadisu. Do you have any additional document which you provide to Shireen to book the transaction? You know why this email I sent in December 2021? Because I was during that period I was under suspension, and this transaction was not under investigation also. So
well,
I have...
hold on, because I'll come on to that. But I'm talking about this email in 2017, not 2021.
Yes.
So in 2017, it's already been flagged at this point in time that someone is asking for supporting documents. Yes, Shireen is asking for supporting documents.
Yes. And I forward the same email to Mr. Sadisu. Of course, they received the document in their level. For me, this is same like transaction for 2016. We released the money for Sudatel, and Sudatel booked the transaction in Sudatel level. So for booking the transaction, for registering the transaction, they might require some additional documents, how they utilize the money.
Well, I think what's being suggested by you in your witness statement is that I think that there were documents in relation to this transaction, but somebody has deleted these because of my investigation and because of these proceedings. And the reason I'm showing you this email is because this predates anyone's awareness of this. This is June 2017, and already by July 2017, we've got Sudatel saying we want supporting documents for this. Yes?
Yes.
So if it is correct that at that time, as you, I think, try and recollect in your witness statement, that those supporting documents would have been sent, or as you put it, some sort of instruction was received by Sudatel, you would have been in a position to forward those supporting documents back in 2017 when this email was sent, correct?
Yes.
The fact that you didn't suggests that those documents didn't actually exist at that time.
Yeah.
Because if they did, you would have sent them.
Yeah. During that stage, I already provided the available document, that was the memo for utilization of amount. But if they need any further document, then they have to get it from their higher managers.
So your evidence must be that you're not in possession of any additional supporting documents at this point in time in July 2017, because if you had those documents, you presumably would have sent them back then.
Yes, yes. Yeah, even for both transaction, there is no additional document from my side. the additional document should provide from Sudatel higher management.
Okay. And if you go up to the top of this page, we've got your email on the 9th of December 2021. Hope you're doing well. Reference to the below. Could you please check your email for any additional documents which you provide to Shireen to book the transactions, and she requests for supporting documents as per email below. I want to prepare a summary of this transaction. Now, it must be the case that at this time in December 2021, you've still got access to your company email system, correct?
Yes.
So if there were documents exchanged, as we've seen in previous examples of transactions, invoices forwarded, approvals forwarded by email, if those documents existed in your email account, you would have been able to find them in 2021 because you had access to that.
Yes, if there is any additional document which they provide to me, but in this case, I have no additional document. But I believe Mr. Sadishu or higher management, they provide additional document to Shireen to register the transaction. That's why I'm just inquiring, is there any additional document? Please send to me, because this is the time the criminal investigation has been started in Dubai, and I was under suspension. I cannot go to office and collect any physical document.
Yeah, the point really is that for all of this window of time, there isn't some document you say which existed and which you had, but which you can no longer access. You're just saying, I haven't got anything further to what I had back in 2017 when this transaction was booked.
Yeah, for booking the transaction, of course, I provide the document, but for further additional document, I don't have.
Yeah. And so let's look at the totality of what you don't have when it comes to this 2017 transaction. So we know this is another one. It's another transaction for $1 million. The foreign exchange is carried out again by Wall Street Exchange. This time it's a bank transfer rather than cash. That's right, isn't it?
Yeah, it was bank
At least that's my
transfer.
understanding. Would you agree, first of all, just to see what common ground we have? First, there is no approval for this payment from EXPRESSO's executive committee.
Sorry?
There's no approval for this transaction by the executive committee of EXPRESSO. Do you agree?
The question is not clear. What is the question?
So I'm just trying to work out if you and I agree with the following statements. First, do you agree that for this 2017 transaction, no approval had been received from EXPRESSO's executive committee for this expenditure?
No approval received means, you mean the instruction or approval?
I mean, a formal approval for the disbursement of $1 million. There's never anything like that from an executive committee of EXPRESSO.
No, I couldn't see any attachment.
No.
Yeah, I can
There
say,
is...
I didn't get chance to go and check physical file, but in email I couldn't see. I searched for the email.
Yeah, and we haven't seen any what you might call as an underlying document or a source document showing an invoice or an explanation of what this particular payment is for. We don't have that here, do we?
No, there is no invoices. In this type of transaction, we cannot expect any invoices.
Yeah, there is no email from Sudatel to EXPRESSO saying we authorize or we are requesting you to transfer $1 million to us.
When I was checking email, I couldn't see any such type of document. But after transaction, of course, there is emails.
Yeah, I'll come on to the documents that we do have, but there's also presumably on that no documents from Sudatel saying we want to effect a payment to this third party. Can you please do it for us? Do you agree?
Sorry again, could you please repeat the question?
So there's no communication from Sudatel to Expresso saying, we want you to make a payment to a third party of $1 million. Can you please execute this?
No, there is no such instruction. I couldn't see an email. And this is not for third party.
There is no, given that this is a bank transfer, there's no transaction approval document from Expresso with the A and B signatures or the company stamp, correct?
That's, I'm not remember, maybe the document I already submitted. Company stamp and signature must be there, I think. I'm not sure, but I have to check that document. It was a bank transfer, not check.
Yeah, it's a bank transfer, but we looked earlier at a number of different documents that were called transaction approval. So those are the forms where your signature was in the left-hand side, Mr. Rahamtala's was in the right-hand side, and there was the company stamp. But for this transaction, we don't have one of those.
Do you have that document, like, the page
No,
number?
That's somewhat my point, is we don't have the document, do we? Are you aware of that document existing? Perhaps I can put it that way.
There are some documents regarding the bank transaction. That's I remember.
I'd also suggest to you that for this transaction, we don't even really seem to have the email from Mr. Rahamtala saying, can you please execute this transaction? So we don't even see an internal email from Expresso saying, make this transfer.
For 2017 transaction, why I'm saying like this, I was unable to search those documents physically. I depend only the emails, but I couldn't see any emails.
Yeah.
Maybe
so when you searched your emails, you couldn't find an email, say, from Mr. Rahamtala or from Sudatel saying, please do this for us.
Yes.
So with that in mind, let's work through the documents that you say you do rely on in explaining why you effected this transaction. And the first document you refer to is page 227.
2017 transaction, since I was under suspension and this transaction was not under investigation, I have no option to provide all the supporting document which you are suggesting. But I tried to get maximum document from the email. So these are the documents which I receive. Yeah.
So this is effectively the memo or the resolution you say, which explains the utilization of funds. It's the 3rd of April 2017. It says at the top of the page, it's Sudatel Telecom Group Board of Directors resolution. And if we read it, it says the committee reviewed the memo about the donation of some government agencies in Guinea. The recommendation is to be recorded that's an amount of $1.5 million as a deduction from the social support balance. After dealing the members and listening to their opinions, the committee decided the foregoing. The committee approved the donation of $1.5 million to some government agencies in Guinea to be recorded in the minutes of the main centre as a deduction from the balance of social support. So this is, as far as I can see, the only contemporaneous document that appears to be relied on in this transaction. Let me just ask you a couple of questions about the content. First, you say that you're the standalone accountant for Expresso. And so it's Expresso that employs you, not Sudatel, yes?
The question is about the memo, right?
It's about the memo. I'm asking you a preliminary question, which is you're Expresso's accountant. You're the accountant for the standalone entity. You're not Sudatel's accountant. Yes?
Yes.
There is nothing in this memo anywhere which says anything about Expresso. Correct?
Yes.
It doesn't say EXPRESSO will pay the amount of $1 million on behalf of Sudatel, does it?
The memo says the money should arrange from EXPRESSO.
Where does it say that?
Where is that memo? Can I have the
page 227?
227. No, sorry, not in this memo. There is another board resolution.
Okay, I'll come to that. The amount that's referred to in this memo is different to the amount you transferred, isn't it? It's $1.5 million, not $1 million.
Yes. $1.5 million. Yes.
Yeah. There is no evidence or email chain, for example, showing that this document was ever actually sent to you at the time. Would you agree?
Yeah, it's not available with me.
Yeah. We haven't got any evidence at this trial, for example, of Mr. Rahamtala sending an email saying, "Dear Mr. Moorkhath, please see attached memo. Can you arrange to have $1 million transferred pursuant to this request?" There's nothing like that, is there?
I couldn't see any, while I'm searching, I couldn't see any email.
The next contemporaneous chain of documents we have begins at page 232. This is from the 3rd of May 2017, and it's the chain of emails through which the request is being made to Wall Street Exchange to arrange for these funds to be converted and transferred. So you see at the bottom of the page 232, "Dear Betty, please could you give us today's rate?" As we continue up, she responds, providing you the rate. Over to 233 at the bottom, "Can you please provide the bank details so I can send you the dirham amount?" Above that, she says, "Here are ADRB details." Bottom of 232, you respond and say, "Thank you for the details. Please find attached this document." She asks for a passport copy. You provide it. And you say, "Please find attached." And that's the end of this email chain. Now, there is no one in this chain of emails copied in from Sudatel, is there?
There is no Sudatel people copied on that email. Only Mr. Husham Sulaiman and Tariq Hamza Rahmatullah.
No. There's nothing in this email chain which gives us any insight into what the purpose of getting these funds are or what they're going to be used for, correct?
Correct.
So when we look at the documents that exist and that we have available prior to this transaction being effected, isn't the problem you have in 2021 when you come to piece this together, or you try to piece this together, the reality is that you can't, because none of it has been properly documented as you would expect of a normal company transaction.
But as I explained, I was expecting some more document related to 2017. Unfortunately, I'm unable to go and search this document, this physical document. You can see these old documents, I got it from email. There is no bunch, as you explained before. It's not a physical document documented in file. This is all soft copy. So what I'm trying to say, if I'm in a position to go and search the physical file, I'm sure I can find some other document if it is, properly keeping there.
But this is the point, isn't it? You're EXPRESSO's accountant. You're the person who was responsible for making sure that if you have a large transaction like this, the documents are available to explain what on earth has happened. But you haven't done that, have you?
Yes, I'm the person who is keeping all this record. But 2017 transaction, it was not under investigation. 2016, of course, when I was in office, they started the investigation. I was able to go and search the document. The investigation starting after 5 years. So this was, comparatively old document we kept in archive. Even though I go and search the document, I found those documents. But 2017, I was not in a position to search physical document.
Your job isn't to maintain proper accounting records only if there's an investigation. We looked at the company law. Your job was to maintain accounting records whether there's an investigation or not. And so I suggest to you that the problem that we have here solely arises from the fact that you haven't maintained a proper accounting record.
No, I properly maintained the document. That's why, the other party, Sudatel, when I send this document, they ask for some additional document. Then I forward the email to their manager, Mr. Sadishu. After that, no more question, no other inquiry, or they have not kept this transaction open. It means they got the additional document, whatever they required to register the transaction. After that, during 4 years, there was no other questions to me, no query.
But it's not about the documents that they require, is it? It's about the documents that EXPRESSO requires. So I suggest to you that EXPRESSO has not maintained any records that explain this transaction.
No, I couldn't say like that. For that type of transaction, of course, we will get sign. Both parties will, me and Mr. Tariq Rahmatullah will sign. But unfortunately, I couldn't provide, I was not in a position to provide those documents.
If we go to paragraph 86 of your witness statement.
Page number?
Yes, of course, it is page number 87.
87.
Mm-hmm.
Yes.
What you're referring to here is another memo. You say the email referenced above is another piece of evidence that Sudatel knew that the transaction appeared on its books and their external auditors gave a note on that donation which they made. Moreover, you say Sudatel's board already approved the transaction as per the board resolution dated the 19th of March 2019, and you refer to the exhibit. Just to be fair to you, if you can pull it up, it's at page 240.
You're referring some page number?
240.
240. Yes.
So this is the memo you're referring to. This is the piece of evidence you say that shows Sudatel's board had already approved the transaction. Now,
Yes.
a few things. This is directed to the National Audit Chamber. We can see that the subject is management letter on Sudatel audit for the year 2017.
Yes.
Just to give this some context, so Sudatel is, as I understand it, a public company. So presumably
Yes.
you would have been aware, even though it's a group entity, that it was subjected to audits by a public auditor or the national auditor. Yes?
Yes.
Yeah. And looking at the top of this letter, it says, after the committee reviewed the management's letter, considered the comments and the financial and administrative issues, held in a number of meetings, in addition to its meetings with executive management and the National Audit Chamber, and submitted the issues below to the Board of Directors in its meeting on the 25th of January 2019, we present you the resolutions. Now, I suggest to you that what this is saying is that the resolutions in this letter are attempting to address a number of issues that have been flagged as a consequence of an audit of Sudatel's accounts.
Okay.
Do you agree with that? What seems to be suggested here is the national auditor has identified a problem in 2017. Here is a resolution which is addressing those concerns. Do you agree?
Yes.
Yeah. And this document is the 19th of March, 2019. So you must accept, surely, that there's nothing in this which would have been evidence of authority for a particular transaction back when you processed it in 2017. This is 2 years later.
Yeah, 2017. This regarding 2017 audit, which happened in 2018, and it's very clear they were reviewed the management letter, considered the comments of financial administration issue, held a number of meetings in addition to its meeting with executive management. So it means internally in Sudatel, this discussion is going on. But for EXPRESSO, there is no such communication during this period. Even we don't know they are not registered or they were waiting for additional document. We have no idea about even this memo. This is happening in 2019.
Yeah, but what you've said about this evidence is this is evidence that Sudatel's board has, you say, already approved the transaction for this board resolution. But isn't the point that this is telling us actually the complete opposite? The very fact that we need this board resolution in 2019 suggests that there was no formal authorization for the transactions back in 2017.
2017, as I explained before, same like 2016 transaction, for transferring, for arranging this amount, this type of approval is not required. This approval to register the payment in Sudatel.
Yes, but your evidence says this is proof that Sudatel had approved this payment. What I'm suggesting to you is that because they're having to visit this retrospectively and provide that approval, it means that there can't have been any evidence that such approvals existed back in 2017.
Yes, even they're talking about 2015, 16, and 17, 3-year transaction. So Sudatel, they managed to get the board resolution maybe in 2019. It's not going to affect EXPRESSO. This is their internal matter.
Let me put this as narrowly as I can. From your position as an accountant for EXPRESSO, given that we now know that Sudatel are only getting around to retrospectively approving a number of transactions in 2019, it's not possible for you to have seen a document in 2017 from Sudatel saying, we approve this transaction.
Because the investigation is happening in 2021. So of course, we will provide whatever the document, even though it's not under investigation, but since this document was available in my email, so I can provide this document, how they got approval for this. Even though this is not my, my duty, how they approve, how they got approval for that particular transaction. But this is, I'm just provided to support how they got approval and how they registered this payment.
So again, I'm not sure that that's an answer to my question. What I'm asking you to confirm is whether what you say in your witness statement can be right. So it cannot be correct that Sudatel had already approved the transaction. And we know that because they are only getting around to it 2 years later.
During this stage, like, while I'm preparing this witness statement, I can say they already got approval. It's already got approval means before the investigation, they got approval.
You had no idea whether there was approval or not when you made the payment, though.
The board resolution, I'm talking about the board resolution.
The 2017 board resolution, that doesn't refer to EXPRESSO, just to be clear about what you're talking about.
The same memo, point 5, fifth point, there is a board resolution.
In 2019?
Yes, page number 243.
I'm sorry, Mr. MOORKATH, do you understand the point I'm getting at? Because I know that it may well be unhelpful to you to answer this question, but I think it's important to get an answer. which is whether you agree with me that you cannot have been in possession in 2017 of any documents showing that Sudatel had approved this payment.
Sorry, Your Honor, I'm only interrupting because I'm not sure that question's fair. I think the only thing that can be deduced is that there wasn't a board resolution available to Mr. Moorkhath in 2017, as opposed to an approval, whether that's an email or a letter that says I approve from somebody, I don't know who that might be. So I think, I'm sorry to interrupt, but I think that clarification is required. Your Honor, you're on mute.
Thank you. I think that's right, Mr. Doherty. If we look at the first line under the bold board resolution, refers to the board approved, and then there is reference to executive management and so on. So I think the point that Mr. Costello makes is correct, that all that one can draw from that is things in relation to board approval, not some other form of, if there was one, other form of approval, instruction or anything else.
Yes, Your Honor, it may well be that I've changed the words I've been using because I think I've asked the same question about 5 times. The specific sentence in the witness statement says, Sudatel's board already approved the transaction as per the board resolution on 19th of March 2019. Paragraph 86.
Yes.
And my question to the witness is to say they can't have already approved the transaction at the time it happened, because this board resolution is only 2 years later. That's the question. That's what I'm getting him to agree or
I think that's a fair question. Yes. Yes, as long as
perhaps, Mr. Moorkhath, if you can look at
cross purposes, as long as, and I think you probably put it at one stage, referred to board approval. As long as you stick to that, the question is perfectly right.
Yeah. Thank you, Your Honor. I'm grateful for that. Mr. Moorkhath, if we can put it in those really simple terms, your witness statement says Sudatel's board already approved the transaction as per the resolution on the 19th of March 2019. Do you now agree that in the context of a transaction that happens back in 2017, that board approval cannot have been already provided because it's 2 years after the event?
Yeah, during 2017, of course, I don't have that memo. I depend only the memo which the previous memo regarding the utilization of amount, 1.5 million in game connect. Yes.
Okay. Now, we can then see going forward in time here is that from having this set of board resolutions that explain some of the background into the problems identified by the National Auditor, if we move forward in time slightly to page 248, we get some understanding of the context in which the investigation into your conduct then arises. So if you open up page 248, in the middle of the page, hopefully you'll find an email from the 25th of March 2021. Do you have that?
Yeah, email from Mr. Abdul Salam?
Yes, correct.
Yes.
And what he says is, Dear FAIZAL, I hope that you're fine and complete health. There are some financial payments from EXPRESSO to Bondi during the year 2016 in the amount of $1 million paid as donation to the Presidency of the Republic. The external auditor gave a note on this donation and submitted it to the Board of Directors. Please provide us with all the details of this donation, along with attaching any supporting documents. Your cooperation is greatly appreciated. So, suggest to you that what this email is telling us is that the auditor has flagged an issue with this transaction. They're not satisfied that they've got all of the documents explaining this, and so they're coming to you and saying, can you please provide those documents to us? Do you agree?
I'm not agree, actually. You know, this email I'm receiving in 2021. This is the reason I use. They already have approval for the transaction. You know, the board resolution 2019, it's clearly mentioned they got approval of the process which they follow for 3 years of donation transaction. Then after 2 years in 2021, it's really strange they came to me to ask for further document. This is not in my hand and this is not related to EXPRESSO. So they're supposed to get any further document or approval. It's from Sudatel only.
Presumably you can see why the company isn't satisfied with a retrospective board resolution that's only made once the issues have been identified. Let me put it in these terms if I can. Your job, the evidence you give right at the outset in response to the questions I was asking you about accountancy procedure, was that you were acquiring documents at the date transactions were effected, and you were making sure that those were stored in the proper way. And so can you understand why a parent company trying to work out what has been going on here would come to an accountant and say, can you please provide us with your contemporaneous records? So what they want is the documents from 2017 and 2016, isn't it?
So
I'll say just 2016 to be fair. It is only 2016 in this email.
Yes.
But the point is they want the documents from the time, don't they?
Yeah. So as you said, that email related to 2016 transaction, not 2017. And this is, I feel, they have to start some type of legal action. This is the first email which I am receiving regarding this investigation. And I replied to that email also. After that, a few months, there was no question. And I really surprised. They were asking document from me related to some internal transaction of Sudatel.
That may well be surprising to you, but what you're not doing here is saying, of course you can have these documents. Here they are. I stored them in our accounts or in our physical folder. You don't respond to this because you don't have the documents. That's right, isn't it?
I don't have documents means suppose I don't. There is no chance for any document related to Sudatel internal transaction. They cannot expect any document from me. If they're saying that money not received in Sudatel, then of course I have to provide some supporting document.
Right. So your position is, I don't have the documents, but that's not my problem. That's your position.
Yes.
Right. If we go to 252, I think you pretty much say as much in the investigation meeting. If we go to the bottom of this page, 1, 2, 3, 4, 5 lines up.
Sorry, page number?
This is page number 252.
252. Yes.
So if you go 5 lines up from the bottom, we've got Moala. It says question, but the documents before us indicate that the money intended to go to Mauritania. Why did you give the money to someone else? And your response to that question is, according to the practice, I'm not obliged to know where the money would end, since it was Sudatel money.
1 second, let me go to that. Which line it is? Page number 252, 1, 2, 3.
Yeah, five lines from the bottom of the page.
Question. How the money is withdrawn. Same question. What is receipt? Yeah. Mr. Moalla was asking to me, but the document before us indicate that money intended to go to Mauritania. Why did you give the money to someone else? So my reply, I was not obliged to know where the money would end since it was Sudatel money. So what is the question in this point? What I understood, they have some document in their hand that indicate the money should go intended to go Mauritania. That is the memo they're referring maybe.
So My question is this: you were the sole accountant for EXPRESSO. You were performing your job for EXPRESSO as an entity. We have a scenario in which money that was in EXPRESSO's bank account is being given to somebody else. And my question to you is whether your view of all of that is simply that this isn't your problem, this is Sudatel's problem.
Yeah, that is very clear. You know, I handed over the money to Mr. Tariq Zain. He is the president of Sudatel. So for me, this is not to third party. So even this moment, I cannot give a correct answer how he utilized the amount. So he provides some document to Sudatel finance department to register the document. Accordingly, they register. For in my case, I handed over the money to Mr. Tariq Zain. That is end of that transaction actually. Then I forward those supporting document to Sudatel. That's clear. No, I have. I'm standing the same reply.
All right. Paragraph 87 of your statement, which is on page 87. You.
287.
No, just 87.
87.
Back to your witness statement, and I'm looking at paragraph 87, where you put forward a hypothesis surrounding your termination from employment. You say, during the month of April 2021, the acting CEO verbally informed me of the intention to terminate my contract for cost reduction due to COVID. And the defendant started bank signatory updates, removing your access. On the 1st of May, you say you received an email instructing you to start the handover process. You handed over everything before traveling to India. You say, unfortunately, your mother was seriously ill. And despite this, it says the defendant decided to keep me employed. Now, a few questions about that. There's no documentary evidence of this sort of discussion taking place at all, is there? So you haven't provided any evidence of Mr. Abdel Malik coming to you and saying, we're terminating you for cost reducing purposes?
The handing over process, of course, I have email, and I have received an email from Mr. Abdul Malik, Mustafa Abdul Malik, and I have some handing over document also. On 5th of May, and handed over all the document. I got signature from Mr. Abu Al Ghazi.
Well, I suppose let's put this in really simple terms. You were on a 3-month notice period, yes?
Sorry?
Your employment contract is a 3-month notice period.
3-month notice, yes.
Yeah. There would have been nothing to stop EXPRESSO from just handing you your 3 months notice, sticking you on gardening leave, and bringing your contract to an end that way, yes?
There is discretion. If company can terminate a person immediate, but they have to provide 3-month notice salary in lieu of salary, in lieu of notice.
If the aim of all of this is some convoluted cost-saving exercise, it wouldn't make any sense to keep you suspended on full pay for 10 months, would it, while all of this is being investigated?
Yeah, that is the surprise thing for me. Before they were talking about the COVID-related issue, deduction of cost, but back of the curtain, maybe they have some investigation going on. I'm not involved in any investigation in that stage. I got informed about this investigation on 4th of May, and they conduct an investigation meeting on 5th of May. So nothing conveyed to me actually. There was no email, there was no discussion about the investigation. It's all sudden happened, and they suspend me instead of termination.
The point here really is that given that we've got these emails asking for the documents surrounding these transactions in March, given that we've got EXPRESSO putting you on 10 months paid leave while you're not in the office and while you're not working, the idea that there's some ulterior motive to get you out for cost reduction purposes makes no sense at all, does it? Commercially.
what Mr. Mustafa informed to me, that's I mentioned here. So the initial discussion was due to the COVID and management decided to make some cost reduction. So we are going to end your contract by end of April. That was the initial discussion. But it's not happened actually. You know, they did some sort of investigation meeting, and immediately they suspend me. This is the only investigation meeting related to this transaction.
Yeah, well, perhaps I can suggest to you this, which is what the company has done is actually been extremely fair to you. They could have just stuck you on 3 months' notice and off you would have gone. What they've actually done is they paid you for 7 months on top of that 3 months because they wanted to be fair to you and they wanted to investigate the allegations properly. Yes.
But the end of the story, I couldn't see any proper investigation has been done. Maybe they have some intention to make proper investigation, but there was no proper investigation done. This is the only one investigation meeting happened. There is no email communication, there is no question, there is no query during this period.
Okay. I'm going to ask you some very brief questions about a couple of your employment benefits. Hopefully we can round that off reasonably speedily. First is about your annual leave. If you go to page 276, we find your contractual provisions which deal with your various entitlements to annual leave. It's at the bottom of page 276 and continues just into page 277. But in effect, it says 24 working days, annual leave taken on 2 weeks' notice. Clause 7.3 says the employee will not be entitled to receive pay in lieu of annual leave that is not taken except approved exceptionally by Vice President of International Operations or when the contract is terminated. And then it says leave accrued but not taken in any year shall not extend beyond March of the following year. Any further extension of accrued leave will only be granted with the permission of the Vice President, is what it says. Now, looking specifically at that last part, the idea that leave accrued but not taken in any year shall not extend beyond March of the following year. It seems like anyone who's in employment would probably understand that you can't just indefinitely roll over your annual leave. So you can't work for 5 years, never take a holiday, and then when you leave, all of a sudden claim 5 years of pay. That's right, isn't it? This contract wouldn't let you do that.
Okay. I have to mention 2 points. The first point is that this was a special situation due to the COVID. Since 2019, I can say beginning of 2020, we are not able to travel and we are not in a position to take any annual leave. That is the reason it's accumulated. And second thing, as I mentioned before, I am the only one person in finance department. I cannot take long leave. Normally, you know, I was getting 5 days, 6 days leave at a time. So that is the reason it's accumulated. And during the suspension period, you know, what I was expecting, anytime within a week or within a month, the investigation will complete and I will be get back to my work. That was my expectation.
Mr. Doherty, do these questions go to the proper construction of the contract? And if so, does it matter what Mr. Moorkhath thinks about it?
No, I flag this. I flag this as potentially being the case. I can skim over the contractual interpretation bits of it. It's just, as I say, as long as no point is going to be taken against me for not asking these questions, then I'm happy to go past. I do have one sort of factual question.
I don't think any point can be taken about you not debating the construction with the witness. Of course, if there is some question of fact which underlies it, that's another matter. Yeah,
I hate drafting the questions. I sometimes put them in because you never know. The factual question I have is specifically when we look at paragraph 87 of your witness statement, which we've just looked at. As you say, unfortunately, your mother was ill, you say, and she passed away at the end of the month, sadly. But on the 6th of May, you say you travelled to India, so that's day one of your suspension. At paragraph 105 of your witness statement, what you then say is that you remain in India until August 2021. So that's a period of, well, depending when in August, 2 or 3 months, yes?
Yes.
So the first 2 or 3 months of your suspension are spent abroad in India?
I was in India, yes. That was the time we are doing the work from home. During COVID time, it was common. And as per my suspension notice, anytime if they request, then I'm available for duty.
Yes, but during this time you're suspended, you're not working.
Sorry?
During this time you're suspended, you're not working. And I make no criticism of it. Quite understandably, you wouldn't be working given the circumstances that brought you home in the first place.
Yes, suspension notice, it's clearly mentioned I must be available for duty if they requested. It's not like, I'm not fully relieved from the duty.
Now, let me just ask you some questions about what you say about your visa. As I said, I'm not going to take you to what the statute says about this. I'll address the court on that in due course. But if you go to paragraph 134 of your statement, which is at page 99.
Page 99. Yes, paragraph
134, and it's what you say from the middle of this paragraph.
Yes.
You say, without getting a proper timeline for cancellation of the visa, I was unable to secure any other job. I was contacted by a few companies through references, but when I informed them about visa status, they asked me to wait until the visa was cancelled. Now, I'll suggest to you that that's quite an odd thing to say, and there are a few reasons for that. First, if I can ask you to look at what you go on to say at paragraph 136, which is just over the page. You say, I received a job offer from Messrs. Finance. I don't know if that's finance or Finacle, tax and accounting services. I don't think it matters. On the 3rd of November, this was the same day as the visa being cancelled. In fact, they were waiting for the cancellation of my visa to offer the employment. Once the visa was cancelled, I informed them, and I formally received the offer. Now, I suggest to you that what that tells us is that, in fact, you were being invited to interview for jobs before your visa was cancelled.
Yes, since March, of course, I was trying to get some other job. Like, I received the termination letter, dismissal letter. So when I sent my first legal notice, I came to know now that they were waiting for approval from Sudatel to cancel my visa. They released partial payment against my obligation, but they have no intention to cancel my visa. So when I contact some reference for new job, of course, they will ask about the visa status. And the other thing, at that time, that criminal investigation was going on. So this both, without cancelling my visa, I have no option to join with any other company.
Yeah, I mean, not employing someone while they're under criminal investigation is one thing, but the point here is that there's nothing about having an active visa status with one employer that prevents you applying for other jobs with other employers, does it? I mean, people apply from within their employment all the time.
No, without cancelling, or either I have to provide a promise within these days. I can get cancelled my visa, then I can join. They will ask about the notice period to join to the new company, but I have no answer. It was not under my control when I can get cancel my visa.
And sorry, we're talking about two different things, I think. Yes, when you start a new job, you will have to change your visa from one employer to another. That would be the normal process if you made a job application from being within employment, you hand in your notice, there's the formalities, which is changing the visa at the end. But there's nothing that stops you applying to another job, is there? Because you've got a visa with another employer. That's just normal.
It's not normal because, you know, I got some offer, the same company, even this same company, Finacle, they were waiting for me to cancel the visa. So
Yeah.
job is there, but without cancelling the visa, I cannot join. So this is the same process for some other other company also. You know, I have in discussion, but due to this situation about my visa, I was not able to join.
Let me break down what I'm going to suggest to you a normal recruitment process looks like. Step one, there's a vacancy and you apply for it. Would you agree?
Yes.
Step two, if they like the look of your CV, they might invite you to attend one or more interviews. Agree?
Yes.
If they like you after interview, then they might make a formal offer of employment. Agree?
Sorry, the third one?
So if they liked you after your interview, they might make a formal offer of employment to you. Would you agree?
Yes. Yes, yes.
And it's only really after you've already got an offer of employment that visa can be an issue, because there's nothing about those first three steps that you're precluded from doing because of your visa status.
Now, for me, as I mentioned, this job offer came through the reference. So it was easy to communicate with them. And of course, they know my background. I was working with this company. So everything they know. So I cannot, you know, lie to them. I can come and join, then within a month I can make the new visa. That was the reason I have experience from 2-3 different, you know, companies. When I inform the situation, of course, they're deny my offer. Actually, they're not they're not ready to give any offer of job.
Yes, but I want to be really clear about how far you're saying you went with it. Like you say, criminal investigation's ongoing, an employer might run a mile from that. But here, you haven't provided, first of all, have you, any evidence of communications with any prospective employers? Do you agree?
Regarding job offer, yes, I'm not provide any evidence.
Yeah, you haven't provided any evidence of those employers saying, well, we would invite you to an interview, but we can't because of your visa status.
That's why I mentioned this job offer came through the reference. So the reference.
Yeah, I'll come on to the job offer that you actually take, but I'm just saying, as a matter of principle, there's no evidence from any prospective employer saying, I'm sorry, but we really can't progress your job application because of your visa status. You haven't provided anything like that, have you?
My experience, you know, when I apply or when I discuss about the job, it's not like, you know, first instance we are not going to start the formal procedure. Of course, they will call and they will talk about the current situation, current salary, current expected date of joining. So this expected date of joining, I have no answer to give when I can join with those company. Then they're not going to make any other discussion. So
well, you did, because you were immediately available. You didn't have another job. Your visa status may well have been cancelled in 24 hours notice. But the point is, you haven't provided evidence that you've been given a single offer of employment before November of 2022. Correct?
That is, you know, I'm not going to agree with, like, you know, I requested 2-3 times formal legal note through legal notice requesting to cancel my visa. Then I got answer. This is under Sudatel approval. We are waiting for Sudatel instruction to cancel your visa. It means I cannot guarantee to any company any time what time I can get cancel my visa.
Where is the evidence that says that a single company at any point in time between March and November 2022 told you, we are not going to employ you because of your visa status?
It's all verbal discussion. I clearly mentioned it was through reference. So it was like, some company I discussed over phone, some company I went there. Then I discussed about the situation. So there is no formal communication.
So you haven't formally applied and interviewed for any other jobs, so far as we're aware of, apart from Finacle Tax and Accounting?
Even Finacle also, it came through reference, and I was waiting to cancel my visa. And meantime, one more event happened. Actually, my visa has been expired 15th of September. And during that, after 15th of September, I was staying here like grace period till October. So that was very, very difficult situation for me. I was waiting for this cancellation.
All right, Mr. MOORKATH, I'm just struggling to see whether you understand the questions I'm asking you, because it's your case that you should be paid for a loss of earnings from the very moment that your employment is terminated through to November. So you say that the next day after your employment is terminated, you would have been able to get a job, but only for this blasted visa issue. And now what I'm suggesting to you is that the only evidence we have of you receiving any job offer or even making an application for any job is the one that you ultimately land in November 2022. So you get that offer on the 3rd, yes?
Yes, that is the proof actually,
Yeah. It's coincidental, I'll suggest to you, because you get the job offer on the 3rd of November and your visa is cancelled the same day. But it wasn't the visa that was preventing you from getting the job. It was the fact that you needed to apply to get a job. That's perfectly normal, isn't it?
Yes. So they were waiting to cancel my visa. I have communication with them. So once they got cancelled the visa, then they're okay to give the job offer.
Do you have anything from this employer, from Finacle Tax and Auditing Service, saying that we are willing to hire you on the 24th of March, subject to your visa being cancelled?
And I clearly inform I have no formal communication.
Right. On the 24th of March, did you apply to any other jobs?
Sorry?
On the 24th of March, had you so much as submitted an application for another job?
24th of March means
the day after you were terminated.
24th of March, yes. But after that, of course, within 6 days, I sent my reply, and I was waiting. That was, I feel it was my notice period. So at least before finishing my 3-month time, EXPRESSO will settle. So this time, I have no formal communication with any employer, but I have some offer, like verbal, or this is through reference, I got some offer.
All right. Well, I think you potentially answered the question at the end. Eventually we got there. Now, if we go, please, to page 495.
Page number 95.
You should see an email exchange from the 28th of September 2022.
Sorry, I go to some different page number. Page number, could you please say the page number?
Yeah, 495.
Yes.
Do you see this is an email from Mr. Mimi Tavera? Dear FAIZAL, good morning. Hope all's well with you and your family. DRC notifies that your visa has expired already and we need to do the cancellation of your visa. in doing this, you need to cancel the visa of your family first, so we can proceed it with yours as well. Please let us know once completed. You respond to that. Thank you for your email. Hope everything is well. Reference to your email, please note that my lawyer has already sent a legal notice regarding my employment dues and settlement. We're waiting for a reply to the notice, since my visa cancellation stroke renewal is part of the notice. So here, you're being asked, can you please cancel your family's visas so that we can cancel yours? Your response to that is saying, this is an issue in the litigation.
Yeah, this is the first email which I received from the company, EXPRESSO. They're talking about visa cancellation. So September 28 means I sent my third legal notice on 22nd of September, and I was waiting for the reply to that notice. So this visa cancellation is my suggestion. I have to cancel my visa, and I was waiting for my due payment. So of course, I will wait for the reply, and after the reply, I took the decision.
Well, the point here really is that on this date, it's in your hands, isn't it? You're being told, cancel your family's visas, and we'll fulfill these formalities to cancel yours. Yes?
This time, yeah, if I decide, I can support with them after 28th of September. It's fine, but my reply was very clear. I was waiting for the reply to my legal notice.
Right. Well, the point is, it's in your hands now, isn't it?
Sorry.
It's in your hands. The ball is in your court. The next step that needs to be taken is you need to cancel your family's visas.
Yeah, after September 28, yes.
Yeah. And presumably up to that point, that's what's giving both you and your family right to reside in the UAE as anything other than tourists.
My family was residing with me here in Dubai, yes.
Yeah, under your employment, under what would have been then your existing employment visa.
Yes.
And there's no suggestion that the next day, on Thursday, the 29th of September, you started employment somewhere because this visa issue had finally been sorted out.
Sorry, I couldn't get the question.
Right, well, this email's at the end of September. You don't start work with a new employer until November 2022. The ball's in your court. You aren't suggesting that some problem stopped you from starting work with a new employer on the 29th of September after you sent this email?
Yes. I have to mention one point with this question. Till 16th of August, I was waiting to get a verdict from Dubai prosecution. So I got discharged from the criminal investigation. So of course, what I believe, EXPRESSO will settle me since they mentioned this criminal case as a cause, and the cause is not exist. So I believe EXPRESSO, if I send the final legal notice, of course they will come and settle, and I will get my obligation. So that was the expectation. I sent the legal notice, and I was waiting for their reply to settle my. Even during the cancellation, I was expecting they will settle my obligation, but it's not happened.
At paragraph 138, one of the things you say is the late cancellation of my visa was completely the defendant's fault, and I'm claiming my loss of earnings from the period of termination, so that's immediately until the commencement of my employment on the 16th of November 2022, as you corrected earlier. You say my monthly salary consisted of the following, and what you set out is your EXPRESSO salary. So it's your basic salary, your living allowance, transportation and fuel, and housing allowance. Now, I suggest to you that doesn't really make much sense either. After your employment's terminated, you didn't have any entitlement to any salary from EXPRESSO. Presumably, we can agree about that. So if you don't work for them anymore, you don't get paid an EXPRESSO salary.
After the dismissal you're talking about, right?
Yeah, after your dismissal.
Yes, I was not receiving any salary during this period.
So whatever loss of opportunity you feel you may have sustained, that could only ever really be a delay in getting new employment somewhere else, wherever that might be, and whatever rate someone was willing to pay you. But it's right, isn't it? You haven't provided any evidence of what your current remuneration package looks like.
Yeah, currently I don't have any evidence, but my current salary, maybe it will support your question. My current salary is almost same.
Yeah, and the point is, what you're actually claiming is, I want a continuation of my EXPRESSO salary through to November. That's what your financial claim is.
Yes.
Yeah. Final question, which is to pick up on something you say about process. Paragraph 110, and this is a reference to the termination provisions in your contract. You suggest that to terminate you for calls in this way, there needed to be some form of notification to the Labour Department under clause 12 of your contract. Now, I just want you to look briefly at page 498 of the bundle.
Page number 400?
498.
498. Yes.
You should hopefully see an email from Mustafa Abdul Malik. This is to the DIFC authority, as I understand it. It says, "Dear Sir, Madam," referring to a meeting that had been held a couple of days before. We'd like to inquire and take DIFC advice in relation to a case of one of our staff. Mr. FAIZAL BABU is the Director of Finance, and the company currently suspends him due to a suspected financial breach. The company already reported the case to Dubai Police, and presently the matter is under investigation by police and has possibly already been transferred to the General Prosecutor. We're still paying him his salary, even though he's not resuming his work duties, and for that reason we intend to terminate his contract. The termination will be for cause, so you'll not be entitled to the notice period. So I'd suggest to you what this email is, February 2022, is a notification being provided to the DIFC a month before your termination. Do you agree?
Sorry,
I can see this.
Sorry. Can I interject? Sorry.
Yes.
I'm not certain Mr. MOORKATH should be able to answer this question. This is a matter of construction for Your Honour, not for Mr. MOORKATH.
Yes, Mr. Doherty, that seems right.
I think it's whether he accepts that this email was sent as a matter of fact. I'm not asking him to interpret the provision of the contract, just that he accepts that an email of this nature was sent.
Well, he's not in copy on the email. The email's been produced. I think this is a matter between my learned friend and I to debate tomorrow, as opposed to Mr. I'm not saying Mr. Doherty can't make his point. He can make his point in the closing. I just don't think he can make it now, that's all.
Yes, Mr. Doherty, it's not relevant what Mr. MOORKATH thinks is the effect of this email, and if the email was sent and received, whether or not it satisfies the contractual requirement. As to whether it was sent or received, unless you have some reason to say that Mr. MOORKATH has something to say about that.
Yes, well, I suppose it really doesn't matter in a sense, Your Honour, because you have the document and you've seen it, and that's kind of all that matters, really, is the reason I referred to it predominantly. Mr. MOORKATH still saying in his witness evidence that no such email was sent, and the point of taking him here is to rebut something that he says in his evidence. So that's the reason.
All right. Well, I will accept Mr. Costell's objection and won't ask you not to pursue that question.
In that case, Your Honour, unless I'll just double check with my instructing solicitors, I think that's potentially me finishing off on my serve by hitting it into the net, if I can put it in those terms. Bear with me. No, I think those are all my questions.
Mr. Costel, do you want to re-examine?
I do.
How long
I
do you
would
think
like.
you might be?
Well, this is it. I'm hoping not to be more than 15 minutes. I really hope we can get through it quite quickly. It is 5:30 Dubai time, however, so I can wait until the morning as well.
All right.
I'm conscious that I'm probably the one in the sort of earliest time zone, and if it if it helps anyone, I don't really mind if we start sort of 15 minutes early or half an hour early or whatever it happens to be tomorrow. I'll leave it to Your Honour. But I'm aware that the court staff are staying late, probably more on my behalf than anyone else's.
Well, we're currently scheduled to commence at 12 noon Dubai, which, if my sums are right, is 8 a.m. London. If you're willing to start at 7:30, Mr. Doherty, I think that would assist, and we can do the re-examination in the morning.
Yes. Sorry, I spoke before, Mr. Doherty. I didn't mean to.
I mean, it's fine from my perspective.
I assumed agree. Sorry.
If I can just check from my instructing solicitors,
yes,
through the helpful medium of WhatsApp, that doesn't inconvenience our witnesses or in any way. It certainly doesn't trouble me. I've got a 3-week-old at home, so I'm up all hours anyway.
Oh, so
all right.
Similar to me.
Well,
Except I'm
that's fine. 7:30. 7:30 is okay.
All right. I'll just check with the court officer. Ms. Norton, is there any difficulty with us starting at 11:30 Dubai time?
Not at all, Justice Lemiere. 11:30 start time is fine.
All right. Well, thank you all. It's been, I'm not sure, a long morning, afternoon in your different time zones, and we will adjourn. Mr. Moorkhath, you will have to, I'm afraid, resume your evidence in the morning or tomorrow at least, and because you're still giving your evidence, you're not able to discuss or have any discussions with your lawyers overnight, so that will have to wait.
Okay.
Your Honour, can I just ask for one very, very narrow exception, which is only to do with IT?
Yes.
In case we have something similar arise in the morning, can I just have permission to just call him if I need to, just to explain?
Yes, of course. On purely administrative matters.
Yeah.
That certainly is all right.
Thank you very much.
Okay.
All right. Well, thank you very much. We will now adjourn until 11:30 a.m. Dubai time tomorrow.